the state. A matter was assigned tomorrow in the week list and I am supposed to give reply. It is not possible on my part because I will go outside in a urgent work.
What do you want? After vacation?
After vacation.
Which one?
Item 8 of the
Weekly list.
Yes.
8 weekly list after vacation. Okay. Yes. Any mention? No? Sure. Start from.
Weekly daily, item 1.
Oh, the same matter.
ରିପୋର୍ଟ ତ ସେ ଆସୁ ନ ଆସୁ ଆଜି ବି ତଳ କୋର୍ଟରେ ଅଛି କହିଲେ ଆଜ୍ଞା ରିପୋର୍ଟ ଆମେ ପଠେଇଦେଲୁଣି ଭେରିଟି ଅଫ ଦି କେସ୍ ଫାଇଣ୍ଡ ଆଉଟ୍ ଆଇ ଏମ୍ Lordship may see the FIR was 99.
Directed to obtain a report from the land special judge also. Report has come? Yeah?
No.
Any report in? Notes देखो. Right, let us see the note whether it was called for. What is the 29/4/26? 29/4/26. 29/4/26. Report not received. No, it was sent to the consent court.
No.
Huh? Ask the judge to give the report. What is this? Let us get the report. No, the problem is if there is a judicial order, it has to be complied.
ସେ ତ ଦବା କଥା
Hmm.
ୟା ଭିତରେ 1.5 ବର୍ଷ ପରେ ହେଇଗଲା
So let me see whether.
non compliance of my lord's order.
Yes, that is the reason I am.
Now, other coordinated bench has passed 2022.
We'll see why he has to give a report.
18
That's all.
months has been granted.
And twice it is extended and all so many things are happening.
ତାଙ୍କୁ extension ମାଗିଲେ ତଳ କୋର୍ଟ
ହଁ.
କୋର୍ଟ ବି ଦେଲେ 6
Let
ମାସ
it be tomorrow. Huh? Let it be tomorrow. Tomorrow. Let the report be called for. And by the order dated 29/4/2026, the report was sought from the court of so and so. How the report has not yet been received. Hence, release the matter tomorrow. The registry is to make sure that the report is obtained from the special judge vigilance conduct in connection with the. Yes.
Item 2.
May it please your lords, this one. Lordship.
Item 2.
On 12th, my lord, your lordship, asked.
Order file.
Hmm.
When the picture is not fun. Rule of superiority. During that, more use more time.
What is there? Jharkhand has already followed it. Why don't you follow it?
Exactly, lordship, we can dispose of the matter
Huh.
accordingly.
But the fulfilling of the rule. And in case in the state of Jharkhand, they have consulted the state of Bengal, then that will be applicable to the law.
That's what I'm saying. Why are you see a problem?
Clarifies.
Once you dispose it up, your work will not be done.
Yes,
Again,
my lord,
it will-
exactly, my
Better
lord.
it should be pending. At least
Uh,
get the.
Let them not finalize, my lord. If that they do, my lord, it's infructuous, my lord. Let them not do that, my lord, till the damn matter is taken up, my lord.
In that, they have raised the such question before the authority.
Huh?
And that is the.
Where is the notification?
Annex 1, my lord.
Yes.
This they have issued without, my lord.
And by the order dated 12/5/2026,
Right.
the direction was issued to the London State Council to obtain instruction in regard to the implementation of the gazette implementation of the notification dated 4th November 2024. Letter counsel for the standing counsel for the transport department submits that this notification being a preliminary, it is a preliminary notification.
Yes, my lord.
It is a preliminary notification. There is, and the objections has already been invited from the concerned, from the stakeholders. There is no chance of the notification being implemented at this
A finalized.
finally implemented at this stage. In view of, at the same time, he submits, he seeks 1 week time to obtain further instruction in the matter, lease the matter immediately after vacation. I have just recorded your statement that you are not implementing it, being the preliminary list. Yes.
Item 3.
But at this point, madam, no notice need to be required.
No, he's there already. Yes.
And to the other man
It
respondents.
should have been disposed of.
Yes,
Once it is disposed of, again you have to come.
No, my lord.
So let it be there at least.
The other respondents are there, my Jharkhand authorities. If notice can be issued to them.
Shall I issue notice then? Time is there 1 month of, we can save the time. Okay. Issue notice to the
Coram.
respond. Yes.
Ma'am.
File the process.
Yes, ma'am.
Yes.
Deeply obliged, ma'am.
Item
Yes.
3.
Wait, please, my lord. I may be permitted to submit on behalf of Mr. J.P. Negi, my lord.
Right.
The petitioner herein prays for the correction of particulars under father's and mother's name of his son's 10th and 12th certificate issued by CBSE, my lord. The petitioner had under annexure 1 and 2 applied to the school, that is opposite party number 4, for correction. But the school refused to accept it on the ground that as per Rule 69 of the CBSE bylaws, as the same is not supported by the declaration of a court and subsequently published by on the official gazette, the same could not be considered, my lord. The same issue was before my lordships, wherein my lordships relying on the judgment of the Honorable Apex Court in Jigya Yadav case.
Where is the rejection letter?
They have not rejected,
if-
but with the
if I-
interference of my learned senior, now they have accepted.
If I'm allowed to interrupt,
Yes.
the instructions taken by me is, they have received the documents in toto from the school on 29, they had called for the documents on 27th of April, and they have received it on May 8th. That has to be verified, and finally it has to be sent from the regional office Bhubaneswar to the head office at at Delhi for the approval of the competent authority, who is the chairman, opposite party number 2.
So this writ petition is premature unless it is rejected. How can you come? The process is, this is under process. You have submitted the document in May
No, my lord.
to
It is only after the-
CBSE board.
It is only after the interference of my learned senior.
Whatever, now,
Yes,
the fact remains, now they have received all document, they'll verify and pass a final order.
Yes, ma'am.
And if you are aggrieved, you can come.
Yes, ma'am.
That
So-
is a better idea to,
As per
you
the,
are appearing for whom?
Opposite party number 2.
Two. On which date the documents were?
Documents were received from the, was called for by the regional office Bhubaneswar.
Clearing counsel for the opposite party number 2, Mr. So-and-so, at the outset submits that.
The documents was called for by the regional office Bhubaneswar on 27th of April.
And the.
From the school.
Process of, and forwarded to the competent authority for the purpose of taking decision on
The regional office has received it.
grievances of the petitioner. And thereafter a final order will be passed in that regard. Yes, final order will be passed in that regard. Since there is no final order and it has been passed by the competent authority, and the prayer made by the petitioner of this petition seems to be premature. Hence, this court is not inclined to entertain the petition in this case. However, liberty granted to the
my
petitioner.
lordship, the petitioner's son's passport application is being held up. He has applied for.
Therefore, I'm saying,
Time,
I pray
we need time.
I'll give time.
my target.
At this stage, however, liberty is granted to the petitioner to renew the prayer if further so advised, if further petition survives. And it is expected that the competent authority shall do well to see that the final order in the final order regarding the grievance of the petition is passed within a period of how much? 1 month, 2 months? 2 months. 2 months?
2 months ago.
Within a period of 2 months, yes. With this observation, petition is disposed. Yes, next.
Item
My
four,
lordship, may I make one small prayer? My lordship may also observe that while considering the petitioner's case, the Aadhaar card, which is a public document.
Those things I can't make.
My lordship,
Permissible it is, permissible it is, not permissible, not
it's
permissible.
permissible, my lord, as per.
Then permissible, why are you apprehensive?
I'll supply a copy.
No, I can't say anything on merits. You have given the document, they'll pass the final order.
Hello.
I can't adjudicate.
That part it's permissible under the bylaws, so we don't have to object.
Yes.
And he's, see, you are lucky that you have got
I'm
him.
thankful
Got
to my
him.
learned senior appearing for the board for.
He will get it done, don't worry.
Much obliged.
Okay.
Yes. Fourth.
item four,
Item 4, if I may please your lordship. Yeah, Annexure 3 is the impugned order, my lord. Yes.
Annexure 3.
Annexure 3, my lord.
Yes.
The order passed by the Tahsildar. The gist of the matter is that the petitioner bought a portion of land measuring 740 decimal, my lord. But in the HAL operation, the area was reduced to 724 decimal, my lord.
Hmm.
So he filed a revision case before the Member Board of Revenue. Member Board of Revenue, my lord, if may turn to Annexure 2, passed a specific direction at page 20, my lord. Para 7.
Para
7. Page 20.
page 20.
Yes, my lord.
Annexure 2.
Annexure 2.
Annexure 2 starts from
It
page
starts from, my lord.
23.
Annexure 2 starts from page. Annexure 1, my lord. I humbly apologize. Annexure 1
Hmm.
at page 20.
Yes.
The Tahsildar Chutney is therefore directed to verify the areas of HAL plot number such and such
Hmm.
of HAL Khata number 47, Suit Moja, Nilakantapur, through repassing of their areas in the HAL map and by field verification measurement. And in case the areas is/are found to increase on verification, then such plots area along with the total area be corrected. The total area not exceeding 740 decimal. That was the specific direction. Now, my lord, may turn to the order passed by the Tahsildar. That starts from
Annexure 3.
Annexure 3, my lord, page 23.
Hmm.
Page 23, my lord, may peruse the
Yes.
third paragraph.
Hmm.
Before
this
that,
connection.
third paragraph. In this connection, the RI Gangapada has submitted field position report with field measurement report wide his letter number such and such. As per report, HAL plot number 308 of an area 257 decimal having Kisam such and plot number 309 of area 49 decimal having Kisam such and plot number 310 of an area 376 decimal having Kisam such and such corresponds to plot number 297 of Sabik area 740.
This is the plot.
This is the plot,
Yes.
which was purchased.
Hmm.
But further reported that after field verification, the applicant is in physical possession over HAL plot number 308 measuring 257 decimal, HAL plot number 340 part and area 18 decimal, HAL plot number 309 and area 49 decimal, HAL plot number 311 part and area 5 decimal, HAL plot number 312 and area 8 decimal, and HAL plot number 310 and area 390 decimal, total possession 727 decimal.
Where is the plot
RI
number 297 then?
297 is a Sabik plot, my lord.
Where is that?
After-
It is part of this.
Yes, my lord. The Sabik plot after HAL,
Whether against this order, is there any?
there is no
provision of-
provision for appeal.
Yes, what do you say?
But before that also,
Okay.
Yes, public
First
will
is
also
to the
be-
order dated 27/4/2026, the State Council has not yet been received instructions from the concerned department, and she seeks one with them, leaves the matter after vacation. Yes,
my lord,
instruction has not. Yes, next.
item
I have
5,
filed an IA, my lord. Let them not create any third party interest over the suit property, because now it has gone into the
The
record.
government will not do it so easily. Don't worry. Anything happens, then you come.
Yes, my lord.
Yes.
Much obliged.
item 5,
Yes, sir.
My lord, this is the case of the counter case, my lord. As a matter of a civil dispute, my lord.
received CD. Because of that, Lord, who was investigating the case has been placed under the suspense. He has not handed over the file in mediation fact. So that's the reason I am not sure. So the case died with the custody since
My lord, this is the counter case, my lord.
custody since
Since
anticipatory, okay.
and ABL bill, my lord.
Again, same regular anticipatory. Okay. What are the allegations? Let us see. If he is entitled, yes, sir. Let us see the allegations.
My lord.
Allegations
Is in
injury report is there. Do you have the injury report with you?
My lord, I want to release on anticipatory bail, my lord, because there is no cause of action at all in this. I lodged FIR.
Allegation is there in that. Specific allegation. Let us read it.
ସେ ଗୋଟେ ସିଡିଲ ଡିସ୍ପ୍ୟୁଟ ସିଡିଲ ଆମର ଅନାବାଦୀ ଜମି ନେଇକି କଳିଥିଲା ଆମେ ଏଫଆଇଆର ଦେଇଲୁ ଥାନାରେ ସେ ଆମ ଆସେ ଗଣ୍ଡଗୋଳ କଲେ ପ୍ରଥମେ 29 ତାରିଖରେ
କୁରାଡି ଦ୍ୱାରା ମୋ ପୁଅକୁ ଜୀବନରେ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ମୁଣ୍ଡକୁ ଖୁବ ଜୋରରେ ହାଣିଦେବା head injury.
Yes, 16 years old, see that he has the unnatural person.
Stabbing injury and head injury by a kuradi. Unless you show me the injury report, I can't answer.
ସେ ଗୋଟେ ମିଛ ଗୋଟେ ଦେଇଛନ୍ତି ଆପଣଙ୍କର
I don't know. Show me the injury report if you have. Either you have to show, you have to show. Head injury in a kuradi and stab injury in the belly. Unless I see the injury report, how can I help you? I don't know.
ସେଇଟା ସେଇଟା ଆମ ଘରକୁ ପ୍ରଥମେ
So is that civil dispute doesn't mean that you will go and kill someone. Whether he is released from the hospital, whether it is a 302, nothing is known. Injury is such a serious injury.
A simple injury, my lord.
Not dated 24/4/2026. The council person name. Regarding nature of allegation, injury is a thing. It is essential to know regarding the nature of injuries caused to the victims. Victims and the state council is directed to obtain research in that regard, besides obtaining the CD of the case. Please, my friend, 22nd to get it. 22nd. Yes, 22nd. Next.
Item 6.
Yes.
I may please your lordship. In this case, Usko is attracted, so this honorable court directed on 29/4/26
No.
notice issued to the
No, I did
Okay.
6, na? I did 6. No notice was issued yet.
Let's,
We have not issued notice.
35, 3 minutes, notice has been issued.
No, but I have not issued notice in this. It's the first time it is coming.
No, second time.
No. This is
49.
Viranjinaran.
yes, my lord. And
Where is the order? But the order is not there. Anyway, you have issued notice, na? 35.
Lordship, in 35, 3 notice has been issued to you.
So that's because for the state submits that the 35 the BNS notice has already been given to the petitioner. Hence, more is what requires the differentiation disposal. Yes, next.
Item 7.
The document this application in a particular offence silence taken to present 318/4/61 substitute.
What are the allegations?
The allegation is that initially I was not named in the offence. This person who is deficient because of lordship had assisted in opening an account where the fraud was committed. And your lordship on last.
What is your name? You are Propulo Karna.
Yeah.
Propulo Karna. Yeah.
Antecedents, I will be affidavit that I have no other antecedents except this present.
What is your role? Let us see.
Yes.
One for them to That the above mentioned account holder has been opened in account number so.
Your lordship, case during inquiry, it came to know that the other.
As per the direction of one follow karna.
Yes. that is-
Of the near bearer, that is not from so. Now, the assisted and directed, there is lot of. Assisted means you are being getting played by someone else. And directed means you are asking them to play.
Here, words may be.
During scrutiny of the report received from so and so, it is found that the multiple bank account has been repeatedly flagged as the beneficiary account of various cyber and the complaint registered across the state and India. How many cases are there?
That.
Let's here is transaction is 4 crores 36 lakhs 70,000 and deposit is 4 crores 36 and withdrawn is 4 crores 33 and 31 lakhs.
New account.
You are for whom?
I am for the petitioner, yes.
Upon petition.
Yes.
Without my consent.
I have, my Vakalatnama is there. Yeah, appearing.
Who is appearing then? You decide. You decide amongst yourself. You decide.
Delivered by this on.
But I don't want to get into all this thing. You have to decide who. The petitioner has to decide to whom.
Client should take the no objection and then we can appeal.
Simply first half of the vacation. First half of the vacation. You decide, yes.
Time cooperate with the investigation. Your lordship.
No, 4 crores unless the link is established and interstate crime. This is. Huh?
For opening of account, the Procedural and along with
Yes,
Here before the police station, I will submit everything. I may not be arrested, I will cooperate.
But I need to know who is appearing. How can I take your statement if you are not appearing? You don't have power at. I can't take your statement so seriously. But has the client authorized you saying that
Please see, verify the Vakalatnama. Please verify the Vakalatnama.
this is the
Yes, verify the Vakalatnama.
problem. Please send the vacation. Yes.
Vakalatnama.
This is dangerous.
Sir, we will do Vakalatnama.
Yes, next.
Item 8. Oblige, sir.
8, yes. This is regular bill?
Regular.
Yes.
May I
Yes.
Because I am appearing for the informant here.
You are appearing for?
Informant here, that is the respondent number 2, though
Yeah.
the notice has been received by my client, but the petition has not been received. And I am assisted by my learned local counsel, Mr. Dharmesh Mishra here.
Who is appearing? Local counsel. You are. Okay. What's the issue? You are in custody since?
I am in custody matter since 39 to 2025. And the main allegation of rape was against me, for which my I am continuing. But in the meantime, my lord, charge sheet has been
Show me 164 statement.
yes, my charge sheet has been submitted, and in the 164 statement, my lord,
Where is that?
in the 164 statement, my lord, rape is no more there. 376 is not there in 370 has been charge sheeted.
Let's see 164.
My lord.
Because only preliminary charge sheet has been submitted as noted by
So in the
the
final charge sheet, it cannot be rape.
investigations
Once
are
rest-
still
it
going
It all
on.
depends upon the 164
Yes,
statement
yes,
and
my
the
dear.
informant. Victim submits that he has not received the copies for the petitions and along with the answers and the argument. Respondent, informant. Leaves the matter for further hearing and so on. CD has come. Yes. State Council, have you got the CD?
Yes.
Okay.
My lord's copy may be served in course of the day, my lords.
Yes.
A copy, I have recorded that he is
Yes,
submitted the copy.
Yes,
Otherwise, in 21st again, it will be urgent. The thing over. Yes, next.
Item 9.
If they oblige, lords.
8 or 9?
9 minutes.
In connect.
Connected.
Connected Connected in sense? Same accused.
Similar. Other acting.
Same case.
Same case.
Same case. Connect ହେଲେ କଣ? ଏଇଟା ତ ଦି ଜଣ accused, ଦି ଜଣ ଯାକ ଏଇଠି ଅଛି। ଅମୂଲ୍ୟ କୋଉଠି ଅଛି just? Connect ହେଇଗଲା। Hmm. 105 1850 1850 तो गगन बिहारी साहब
Nothing to do with it, na?
Here my lord, seizure of 35 cases from 2 persons. Ganja of 35. कौन केस डेट लास्ट टाइम थिला पढ़ी दसले बोली कहले
Case diary. I have
35 cases गंजा
Both the persons.
हाँ both the persons ଆଉ କେତେ ଦିନ ରହିବ ହାଇ କୋର୍ଟ
35.
to final charge sheet has been submitted on 6/2
Custody since
20/8/25
20/8/25. Charge sheet filed on
6/2/26 final PR
26. And what about the
I have given the comprehensive
antecedent
affidavit
and all?
I have given with
And you are supposed to verify the
apprehensive malad with regards to
affidavit.
picture
Have you done it?
with
I have not received that.
And last time copy was given.
Copy they not.
This is the order to 7/5/26.
order reflect ହେଇଯିବ
Copy of the affidavit has already been served on the land accounts for the state.
malad
Who shall seek?
I have submitting malad 1838 रे नहीं antecedent तारा second रे ଗୋଟେ ବିହାର and Orissa
But in
excise
any
act
case,
ରେ
this is a judicial order. He has to comply this order. Then only I can pass the order.
କିଛି କରିବେନି ଗୋଟେ ଆମେ ଆସିବା କଥା
They nothing copy.
No, this is recorded. How can I?
ହେଇଛି କି ଦିଆ
File and I have complete.
Court order it is recorded.
Yes, sir.
By order dated 21 of 2020, the petitioner was acted by comprehensive affidavit, disclosing the criminal indictment with the status of both those cases. Pursuant thereto, the petitioners have filed comprehensive affidavit, and copy of the same was supplied to the government for the state. On 5/7/2023, the state council sought time for verifying the
21st also can verify
contents of the affidavit, but the same is not yet been done. And see, Mr. Martin seeks one more opportunity. Mr. Naik had taken the copy. That's the problem. You don't keep on changing. Mr. Naik, yeah, last time I told you, don't change the councils every time. You appear last time.
Mr. Naik.
There is also notification of the London Advocate General.
Huh.
Clearly
notification.
directed the office not to alert the.
You see what is happening. You appear. Twice you have been. No. First
Judge Naik.
Aravind Mohanty. Thereafter Partha Sarathi Naik. Why is this happening?
It's a slot allotment, so that's why you fall in.
And you have to put your house in order.
Malad.
You know.
I have also talked.
What generally happens is copy is supplied. You might have kept somewhere. It is not tagged with that.
नहीं तो मिस कर देते हैं
Is the matter.
Oil की दो ना दिन तो ऐसे कि
Verified intent.
associate तो कॉल करी सांगतान तर रोहित फाइल
I have to go by the order.
Your lordship correct. Your lordship is correct.
Yes. Okay. Next.
Item 10.
21st ଅଛି
22nd.
22nd ରେ ଅଧା ଘଣ୍ଟେ 2 ଘଣ୍ଟା କି କୋଟା
Same 21st with I think also same thing will happen. Anyway, 21st.
Item 10.
10 Lordship, here is the case is Lordship 304 IPC my lord, 105 BNS my lord. Russian driving my lord, the cause is due to accidental death my lord. But in this case my lord, what happened on the day of incident my lord, while the deceased going from one place to another place, from the backside one car is came and dashed him, and due to this my lord, he fell down and he facing my lord severe bleeding injury and shifted to local medical.
What is your name? Your name is?
My name is my lord Ganesh alias Krishna Patra my lord. In this case, my lord,
You were driving the car, huh?
yes, my lord, I am the driver, my lord. And both are, my lord, employee of a educational institute, my lord.
Yes.
Millards,
My lord.
vehicle belongs to that college. If that this is your the Millards, one of the shareholder of that college, Millards. And last Millards, when he has made an accident, is talk with that driver Millards in the college. Millards, driver is the staff of that college, Millards. And after returning on the home, Millards, that driver Millards dashed with the backside of the deceased in that the college vehicle, Millards. That's the implicator. One statement of the Kalyani Mahanta, Millards.
My lord, in this case, my
Then
lord,
there was an intention to kill.
No, my
Not
lord.
an
That is the
intent.
intention.
there is
Not
no
a-
intention, my lord. My lord, as per the investigation, my lord, 4 staff of the educational institutes have been examined.
Let us see which.
The director, the chairman, and the permanent driver and the cook.
Let us see what is.
And my lord, out of 29 witnesses, my lord, 7 witnesses have been examined. And in the 7 witnesses, my lord, all the material witnesses, including
Examine where,
including the informant,
trial is started.
mother of the deceased, wife of the deceased, and
Right.
brother of the deceased, sister of the
1
deceased.
minute, I'm asking
Yes,
something you
Yes, my
you
lord.
are singing song.
Yes, my lord.
Oh, tell whether the trial has started
Yes, my lord.
and evidence has already been recorded.
Yes,
Show
ma'am.
me the evidence. If no,
My lord,
nobody
I have
show
already
me
given him, my lord. I'm
evidences so that I can. Yes. Yes. Yes.
Here is, my lord, PW1 is the informant, my lord.
And you are trying to read whose statement?
Millards, it's a statement of Kalyani Mahanta.
Kalyani?
Mahanta.
What he says? She says
Kalyani Mahanta is the PW3. She has been examined.
PW3.
PW3.
Now you just forget now.
Question of
Kalyani,
the-
his testimony has come. Let us see, read it. What he says.
PW3.
5 lakh to the chairman of Technology.
Yes.
My lord, she declared a hostile, my lord.
Incident took place on 3/10/25. My husband was working as an office assistant in Techno World College. In the year 2013, my husband had prepaid such and such amount. Techno World College, namely Dinamantu Mahanta, but he had not returned the said amount to him and my.
But I tell you, this is 1 minute. I tell you, see, all these evidences have come after January 2026.
Yes.
See, Kalyani Mahanti examined
Yes,
on
my lord.
8th May 2026.
Recent.
And all are 8th May, 8th May, all are 8th May.
Yes, my lord.
Your bail application is rejected by the trial court on 1st of January.
First of
You repeat it. The evidence has come later on. Later. Petition is agreed by the order dated 9/8/2026, whereby we let the Sessions Court, let additional Sessions Judge Raidampur has rejected his bail plea in the case pertaining to FIR number 4. The counsel for the petitioner submits that the file of the case has already been. In the meantime, how many witnesses have been examined?
7 witnesses.
7 witnesses have already been examined. And the photocopy of the testimony of all the 7 witnesses have been placed on record. The result of the evidence reveals that all these witnesses have been examined on 8/2026. Since the trial court has rejected the plea on 29 January 2026, thereafter the witnesses have been examined. The petitioner reviewed the bail before the trial court. And if such bail is moved, the trial court, it is expected that the trial court shall decide the bail plea on the basis of the evidence which has already borne on record. These observations disposed of. Yes, next. Item 11.
In this case, my lord, charge sheet has been filed on dated 9/1/2026 and offense under section 137(2)(35)64(2)M of BNS and 617 of
What are the
POCSO.
allegation?
Allegation, my lord. Here I have given the deposition 183 statement of the victim, my lord, at annexure 3, my lord.
Issued on notice. Notice has been served, my lords. Nominated on the victim, my lords, but I have not received any cash debt, my lords.
Engage someone.
Notice has been issued,
In what?
I have not received cash debt, I will keep it at some other.
No, 183 they this statement, they this 183 statement I have given, my lord, under annexure 3, where she has stated that she was in love relationship with the present petitioner.
By the order dated 20, notice was by the order dated 27/4/2026. Notice was issued to the informant of the victim to be served to the IO for the Arakhi Nirakshako means this is IO.
Yes.
IO is wide in the report and placed on record the report dated 14/5/2026. We are repeating that the notice has already been served, and it is also informed to the victim of the informant that in the if she desires to engage avail legal aid services, same is available. Today, none despite service, none is available. In view of the sale, I request Mr. Naidu, I'm requesting you to please appear for this girl, Mrs. Naidu, to assist the court in a history in this matter on behalf of the informant. Give it the copy of the petition. Give a copy.
Yes, my lord.
If the counsel for the petition undertaken to supply the copy of the bail petition and can with the accept to Mrs. Naidu. Yes. Give a copy.
Can it be before vacation, my lord?
Before vacation may not be
Because
possible.
I have given the 183 statement. I
Right, but she is entitled, has been served, and there is an indication that legal services authority council will be engaged. I am requesting her. She needs at least 1 day time. and
one day, my lord, can it be
2
on 22?
Then whole midnight only I will have to hear. You know what is happening? 100, 200 matters are being
Yes,
discussed.
my lord, because in
First half of the vacation.
in her statement,
First half of the vacation. First half of the vacation. First half of the vacation. Yes.
Item 13.
The petitioner is in custody since
My lord,
27.
item number 13, my lord.
Yes.
Item
You
number
are appearing
13.
for.
I am
Yes,
appearing for the victim girl through BC, my lord. I beg an apology.
Yes,
Because today morning,
But already
I
notice
understood.
was issued.
You got the copy today morning, isn't it?
I have received a telephone call from the victim that to appear in the case. And today, by tomorrow, I'll be filing the Bokalapama because the victim girl is carrying me, lord. And the girl has been rescued in pursuance to a habeas corpus petition, and she is pregnant. And this fellow should not be released. But whatever, I pray that a copy of the brief may be a copy.
Restored. Mr. Shodangi, Shodangi presented a period and submits that he doesn't have a copy of the field application and can accept. Then also what the petition to supply the copy.
In course of today, I will supply the
Course
copy.
of the day, we'll see my phone. Yes.
My lord, fix up the date, my lord.
We'll fix our date. Wait.
My lord, 21 or
Fix up the date.
Item
No problem.
14.
Yes, 14.
22.
We'll fix up the date. Let me see first.
Yeah, well, it's the alleged offence are under section 6, 63.
What about the notice?
Notice.
Notice. Notice of Millers, hearing the case, Millers, trial is at verge of completion and posted today itself, Millers. And
The
bail application has been rejected after charge sheet.
For non-prosecution, it was rejected, my lords. I've given the statement of the victim. She has made out a third case, my lords. The initial allegation with the victim was the informant herself, and she has alleged that is the first, my lords. That is the first is the victim's examination herself. She has made out a third case, my lords. Here,
Where is victim? Notice was issued. Where is he has to be there? Service is complete.
Yes.
27/4/2026 notice was issued. Just see
Difficult. You are Govindabad.
My lords.
There is direct allegation.
My lords.
Direct allegation.
But here she, in the initial FIR, which was lodged near about 7 months after the alleged incident, my lord, the girl, in the FIR, the story is completely different from what she has given in the.
Again, appreciation of evidence.
My lords, appreciation.
Notice of Govindabad.
Huh.
I have to engage.
Then let it come after vacation, my lords.
I'll have to engage someone. Yes, Mr. Engage. 27/4/2026. Notice was issued to the informant of the victim. Notice is already been served, but none is here. Give a copy.
And serve a copy.
Yes.
Item 15.
After vacation.
Ha. Oblige me.
Yes. Copy. Yes. In the yes, next.
Item 15.
May I please, my lord? My
Yes.
lord, the alleged offence are under section 302 IPC. My lord, the prisoner is behind the bar since 21/1/2000.
there? Yes.
The prisoner is behind the bar since 21/1/2023, my lord.
21/1/23.
My lord.
Yes.
My lord, the allegation is that the prisoner has taken away money from the deceased and was threatening the deceased not to tell to marry her. And the prisoner was threatening to kill her, and lastly he hanged her after killing her, my lord. My lord, on the previous occasions, my lord, this honorable court has given liberty to file fresh one after examination of CW 10 and 11, my lord.
Give me those evidences. Evidence. Give the evidence. Deposition. What is the last order? By which it is rejected? Where is the last order? 161. Last bail application rejected on? Why are you not placing it on record? I'll go not copy the cost for the business. It's to place on record something to substantiate. Copy the yes. Already. Let me file it. Yes.
May I please discuss my lord.
Friends, on session 112 to 372, 374, 375.
What are the allegations?
Allegation that, my lord, the money, my lord, 10,000 rupees.
Same cyber crime.
My lord, the earlier occasion received directly me.
Cyber fraud and investigation.
Where is the CD?
Last occasion received directly file affidavit regarding criminal activity, my lord. There is no such criminal. I have filed, my lord, that is there in the file.
Have you verified it?
Yes, we have verified no criminal activity.
My lord. And in fact, 10,000 rupees came to
Let us
me.
see what are the allegations.
My allegation there, my lord.
Abhishek Tiwari and Tiwari.
My lord.
Brothers.
Another brother, my lord. What happened in this case, my lord? 10,000 rupees, my lord, transferred through PhonePe to the account of the present petitioner 1, my lord. Thereafter, my lord, when the police department, my lord, searching the same, and they subsequently came to know total amount, my lord, in the account of the petitioner 7,70,000. That is not a fraud account, my lord. Only fraud account came to the account of the petitioner 10,000 rupees, my lord. That is true, my lord.
What
From the
happened
account
to
of
7
MD
lakhs?
Masood.
What happened to 7 lakhs?
7 lakhs are money, his account, he can carry.
Why you are 19-year-old boy and you have 7 lakhs in your account?
19 years and
19-year-old boy and having 7 lakh rupees in your account. Where from you got it?
But that is, my lord, came to the account of the petitioner, my lord.
That is what I am asking.
Others, my lord.
Are what are you doing?
And only, my lord, because the petitioner sent
at a glance, that is the minor
boy.
my lord. And his brother, my lord,
And he has earned 7 lakh.
only because, my lord, he transferred to the brother account, my lord.
You show me what is the source of your income.
Avinash Tiwari, my lord, 19 years, my lord. The petitioner is 22, first. Petitioner one.
Two brothers, 19 and 20.
My lord.
And see the photograph.
My lord. That is my
Not write their name in the English.
My lord.
And earning 7 lakh rupees. You show me their account. let us see the source of their account statement will give. One, Mr. Raghunath, that's what for the petitioner. She's one week trying to place on record the bank statement of both the petition. Both the petition. Please matter immediately after vacation and put it. Immediately after vacation. Reopening. Yes.
Item 17.
17, my lord. 41 kg of ganja, my lord. Recover from the auto rickshaw where the petitioner is the driver, my lord. And another person fled away from the. And I have also filed the affidavit, my lord, stating that there is no such criminal antecedent against the petitioner.
Have you verified?
Yes, no criminal antecedent. But conscious possession, they recovered that 41 kg. From the auto rickshaw, my lord. From the auto rickshaw.
Yes, let us see. What is your name? Jagannath Mahanandiya. Jagannath Mahanandiya.
Proceeding in auto rickshaw tried to escape, however, apprehended this. The petitioner was apprehended since he is the driver of the auto rickshaw.
So, getting the registration number so from the exclusive position of the accused Jagannath Mahanandiya. And it is from the your exclusive.
41 kg, my lord, from two bags, my lord. 20 kg, 21 kg, my lord.
So how will you divide yourself? You will divide.
That is true, my lord. In fact, my lord, he is in custody. 41 kg is also usually a granting bail, my lord.
Custody since?
My lord, in custody. Same day, 18 to custody 19/1/26.
19/1/26. Wait, after vacation. After vacation, you will get it. Yes, next.
Item 18. May I please?
In this case, offence under section 21 CNDP Act, last occasion your lordship directed to file the complaint affidavit, my lord. In same offence, nothing else, other three offences against him.
252 gram
Excise. Now you improvise your profession.
252 gram heroin. Commercial quantity is not.
Call for CD. This is the matter on search. And in the meantime, petition the state council is to verify the antecedent that has been declared by the petitioner by the affidavit. The person who will be also the affidavit filed. Verify. Next.
Item 19.
Obliged. I agree, the lordship. Here offence 23(2)(c)(1). 5 quintal 5 kg. Joint family property.
CD is there?
No, CD is not.
Call for CD. Call for CD.
But technically, I have point.
Let the CD come. Yes.
Item 20.
May I please also. On TV2C of NDPS Act.
Yes.
Petitioner is in custody in 39/2025.
13.
TDC now 2025. 30 kg having no criminal antecedent. I have mentioned in para 6.
CD. Call for
CD.
Call for CD.
Pardon me. The previous item date has been.
Date will fix immediately after vacation, or if you want during vacation, I'll indicate after immediately after.
Permitted to withdraw with change of circumstance, new change of circumstance.
20 item.
Yes.
20. For the petitioner seeks to withdraw the petition to renew the bail plea before the court below on the changing circumstances. The petitioner is disposed of with the liberty to the petitioner to renew the bail plea before the court. Yes.
21.
Maybe. Nothing is seized from the possession of the petitioner.
Madam, 120 kg ganja.
Second time. Second time has your lordship has.
CD actually.
CD.
Nothing from the possession, my lord.
The possession is the quantity is used. Let the CD come. Otherwise, it cannot be.
Saki. Saki
then you file that also.
The CD and
by not related 3C charges of sufficient. He state council directed to obtain CD, but he has not received the CD as yet. And since 1 week time, Mr. Tripathi and council for the petition submits that in the meantime, two witnesses have already examined, and do you have the copy?
Okay.
He has placed on record the copy of the evidence of the witnesses. Give the copies. Advance copy of the same supply to you. Please give it. During vacation?
खाली ऑर्डर होबो ना को मुटियो
During vacation.
खाली ऑर्डर आपन को जदी अछि आपन को कोर्ट रे कर दो
After vacation?
No, my lord. During
ଆପଣ next sitting order କରିଦେଲେ ହେଇଯିବ।
No, no, see, that I can't, but then I will appropriate in every case.
ନହେଲେ ଆଜ୍ଞା ଖାଲି ଆମେ ନଉଛୁ ସିନା during vacation।
No, but the judicial order it will be listed.
No, judicial order ହେଲେ ମଧ୍ୟ ଆଜ୍ଞା ହଉନି, ଥରେ ଆର୍ଜନ ହେଇଛି ମାନେ କିଏ ଛୁଇଁବେନି।
Like, that is a but if there is a judicial order, has to be listed. That's what my understanding.
ନା ଆପଣଙ୍କର ଅନୁଷ୍ଠାନ ଠିକ ଅଛି, ମୁଁ କହୁଛି ସେଟା, କିନ୍ତୁ ସେଇ ଯୋଉ ଥରେ ହେଇଗଲେ ଯେ ସେଟା ଆଉ ଭ୍ୟାକେସନରେ ଲିଷ୍ଟ ହବନି। Despite
judicial order.
Despite judicial order, ମୁଁ ଆଜ୍ଞା କହୁଛି।
Is it so?
Yes, ଆପଣ ସମସ୍ତଙ୍କୁ ପଚାରୁନାହାନ୍ତି।
Why?
The permission of the vacation judge.
Looking into urgency only, some order is passed. So then I have passed many orders like that.
ସେଗୁଡା ସବୁ ଆଜ୍ଞା ମନ ବୁଝିବାକୁ ନେଇଛନ୍ତି। କ୍ଲାଏଣ୍ଟ କୁ କହିବେ ଯେ ହଁ ଭ୍ୟାକେସନ ହେଇଯିବ।
Make sure that all the matters where I pass the order, it will be listed.
ମୋର ସେଇ order
Take it from me.
ଆଜ୍ଞା ମୋଟା
Listing ରେ ବହୁତ ସମସ୍ୟା ଅଛି।
So whether he will entertain, not entertain, is a different story. Once a judicial order is there, it has to be listed. He may entertain, he may not entertain, that is again his discretion. Nobody can have any control. But once a judicial order is there, who is the registry to decide not to list it?
ସେଥିରେ ଗୋଟେ ରହୁଛି ଆଜ୍ଞା କ୍ଲଜଟେ ଯେ with the permission of vacation judge.
Sitting vacation.
Once some these kind of orders are being passed, then some urgency is seen. Therefore, so therefore you have to respect that order and list it. I'll just see.
More
Otherwise, that is redundant.
vacation
Yes.
22.
Offence under 109(2), my lord. Allegation is that when the nephew of the petitioner, nephew of the informant, had went to his nearby chicken shop, he was assaulted by 5 persons, my lord. A group of persons. No specific allegation against any of the accused person, against any of the accused persons. I am for only one of the accused persons, my lord. On the last occasion, the learned state counsel pointed out that there are 2 antecedents against my name. And your lordship had asked me to file a comprehensive.
Yes. Why have you not filed? The order was passed on 1/5/2020.
The mother of the petitioner, she could not give
The
instruction.
problem is you converted this court to a filing counter. That's the problem. It will never go on record.
And I will file it.
The 4/5/26, the affidavit was filed. Affidavit was shown in seems. No, when? Okay. Yes.
There are 2 antecedents. In one of the cases, he has been released on 41A. In the other cases, he has been granted bail.
What are the allegations, Kasi?
Allegation, my lord. Omnibus allegations that when the nephew of the informant had been to a nearby chicken shop, and all these accused persons assaulted him, my lord.
Okay, there is that.
Yes, there is.
You tell me. Alok, Siddha.
Your lordship has also
What are
recorded.
the allegations?
Yes, my lord. May I please, my lord, there are
Because
two-
last time I have recorded that a superintendent counsel, standing counsel for the state has emphatically relied upon the statement of the injured, and which reveals that the allegations are omnibus and in nature, and no specific overtake has been attributed to the petitioner. And she has also pointed out that the petitioner is involved in 3 other cases.
2 cases.
3 other cases.
But 2 cases. That is in the
Please
record.
take it up. 3 or 2.
No, two antecedent is there, but the one witness.
Therefore, I asked him to file the affidavit. And two of the co-accused persons have already been granted bail.
No, my lord.
What is happening to their bail?
The anticipated bail is pending.
Pending.
Fine.
See, what are the allegations against him? Siddharth, huh? Let us see.
That is Alok alias Siddhant Malik.
He is main accused. Yes.
Yes, my lord.
Read it.
May I read, my lord, one eyewitness, my lord? My name is Rinku Malik. May I read my relevant person, my lord? 130 ଭୋଜି ସକାଶେ ମୁଁ ଓ ମୋ ଭଣଜା ସୂର୍ଯ୍ୟକାନ୍ତ ସହ ଭୋଜି ସକାଶେ କାଞ୍ଚିଆ ଗାଁ ଛକକୁ ଚିକେନ ଆଣିବାକୁ ଯାଇଥିବା ସମୟରେ ପୂର୍ବ ରାଗକୁ ନେଇ କାଞ୍ଚିଆ ଗାଁର ଆଲୋକ ମଲ୍ଲିକ କୋରିଆପା ଗାଁର ଦୀପକ ମଲ୍ଲିକ, ଗନ୍ଧିଆ ମଲ୍ଲିକ, ରାଜା ମଲ୍ଲିକ, ମାନସ ସାହୁ, ସଜାନ ସାହୁ, କାମାକ୍ଷାର ମୁଣ୍ଡ ତଳକୁ ଅନ୍ୟମାନେ ସମସ୍ତେ କାମାକ୍ଷାନଗର ଥାନା ଅଞ୍ଚଳରେ ଉକ୍ତ ଚିକନ ଦୋକାନ ଠାରେ ଦଳବଦ୍ଧ ହୋଇ ହାତରେ ବିଭିନ୍ନ ମାରଣାସ୍ତ୍ର ତଥା ଲୁହା ରଡ୍ ଠେଙ୍ଗା ବାଡ଼ି ଧରି ଆତଙ୍କିତ ଭାବେ ଆକ୍ରମଣ କରି ଜୀବନ ମାରିଦେବା ଉଦ୍ଦେଶ୍ୟରେ ଯଥା ମାରଣାସ୍ତ୍ର ମାରପିଟ କରିଥିଲେ, ଯାହା ଫଳରେ ସେଠାରେ ଅଚେତ ହୋଇ ଯାଇଥିଲା। ମୁଁ ଭାବିଲି ସୂର୍ଯ୍ୟ ମରିଗଲା। ସେମାନଙ୍କ ଉଗ୍ର ରୂପ ଦେଖି ମୁଁ ସେମାନଙ୍କୁ ଅଟକାଇବାର ସାହସ କରିପାରିନଥିଲି। ତାଙ୍କ ଘର ଲୋକ ଖବର ପାଇ ସୂର୍ଯ୍ୟ ଘର ଲୋକମାନେ ସେଠାରେ ପହଞ୍ଚି ତାକୁ ମେଡିକାଲ ନେଇଥିଲେ। ତାପରେ 2 ଗୋଡ଼ ହାତ ଭାଙ୍ଗି ଯାଇଛି ଓ ମୁଣ୍ଡ ଫାଟି ଯାଇଛି। ଗୋଟେ ବୋଲେରୋ on the basis of
Main accused. And what about the anticipated bail up for the co-accused persons?
That is pending.
Where is the numbers? Use the numbers.
I'll give the numbers.
Huh?
I'll give.
Give the number. Release the matter along with the eligibility. Persons to the authenticated 1/5/2026. The petitioner has filed a comprehensive affidavit.
affidavit copy may be submitted.
Taken out for. And for the petitioner submit that the co-accused persons have filed a disability bail application, which are pending, leasing the present bail application along with the bail.
My lord, I pass it over because whether the anticipate is pending or not, I don't have instructions.
That is what the last time I recorded.
Well, immediately I'll check.
Verify it.
My lord, I pass it over.
Pass it over. Verify. Roki do it. Kindly pass it. Yes, next.
23.
Yes.
The case of my lord 302 and my last bail application was rejected.
No, CD is not with us.
Person to the authenticated 1/5/2026. The case diary has not been obtained so far by the state. In the meantime, the case diary, the updated case diary is summoned. Yes. Next. 24.
In the meantime, acquitted by the learned trial court.
The submits that the bail application has become in purpose. As in the meantime, the petitioner has already been acquitted in the office. Yes.
25.
25 offense under 310. Yes, my lord.
310A,
395. IPC.
Okay, Jerry.
Correspond.
CD is
Yes.
One criminal antecedent against that.
Here the present petitioner has acted as the informer. Allegation against 6 persons. The main culprit was Vishnu Chandra Mahanti. Who has taken Vishnu Chandra Mahanti.
Okay.
Who has taken all the money along with the Akshay Samal. Only the present petitioner has informed to the other accused persons with regard to the presence of the complainant. So he has not, nothing has been recovered from the present petitioner, only except the motorcycle of your own motorcycle.
Old person seeing him old.
And in the statement of the your lordship, I will read out the Vishnu Chandra Mahanti, everything has been clarified.
Who is Vishnu Chandra Mahanti?
Vishnu Chandra Mahanti is the principal accused.
Principal accused.
Principal accused, and he is it custodian. The last part, Narendra says 16 lakh.
What are the other evidence? Let us see. What
other
co-accused statement?
With regard to the,
if the co-accused have said anything, you will say that don't rely. But if you said something in your favor, you say that rely. Other evidences.
He has not received anything, or he has not
Let's
taken
see
anything.
what are the allegations against this man?
TI period has conducted.
Yes.
Rajendra Dapwa.
Because he was the visitor to the, as an informer, he was the visitor to the complainant. So TI period automatically his name will come.
Yes.
TI period has conducted. সেই সময় ମୁଁ ଏବଂ ରାଜେନ୍ଦ୍ର ଡାକୁଆ ମିଶି ତାର ମୋଟର ସାଇକେଲ କୃଷ୍ଣ ନାୟକକୁ ମଝିରେ ବସାଇ ସେଠୁ ପଳେଇଗଲୁ। ସେହି ସମୟରେ ନରେନ୍ଦ୍ର ବିଶ୍ୱାଳ ଏବଂ ସନ୍ତୋଷ ମହାନ୍ତି ଆମ ମୋଟର ସାଇକେଲ ପିଛା କଲେ। ଆଶିଷ ଲେଲିନ ମହାନ୍ତି ଆମ ପିଛା କଲେ। କିଛି ଦୂର ଗଲା ପରେ ନରେନ୍ଦ୍ର ବିଶ୍ୱାଳ ଏବଂ ମୋର ମୋଟର ସାଇକେଲକୁ ଅଟକାଇ କୃଷ୍ଣ ନାୟକ ଛୁରୀ ମାରି ତା ପାଖରେ ଥିବା ଟଙ୍କା ବେଗ ଛଡ଼ାଇ ନେଇଗଲା। ତାପରେ ଆଶିଷ ଚଳାଉଥିବା ଗାଡ଼ିରୁ ଲେଲିନ ମହାନ୍ତିକୁ ଓହ୍ଲାଇ ଦେଲା ଏବଂ ନରେନ୍ଦ୍ର ବିଶ୍ୱାଳ ସେଇ ଗାଡ଼ିରେ ବସିଲେ ଏବଂ ମିତ୍ରପୁର ଆଡ଼କୁ ଯିବା ପାଇଁ ପ୍ରସ୍ତୁତ। ଏହାପରେ ଲେଲିନ ମହାନ୍ତି ଓ ସନ୍ତୋଷ ମହାନ୍ତି ପଛରେ ଆସିବା ପାଇଁ କହିଲେ। ଏହାପରେ ମୁଁ ଓ ରାଜେନ୍ଦ୍ର ଡାକୁଆ ମିଶି ସେଇ 4 ଜଣଙ୍କୁ ପିଛା କଲୁ। ସେମାନେ ପଇସା ବେଗ ଧରି ଦ୍ରୁତ ଗାଡ଼ିରେ ପଳେଇଲେ। ଆମେ କିଛି ଦୂର ଗଲା ପରେ ତାଙ୍କୁ ନ ପାଇବାରୁ ବିଷ୍ଣୁ ମହାନ୍ତି ଫୋନ୍ କଲାରୁ ସେ ସେଠାକୁ ପଳେଇ ଆସିଲେ।
Then you have a role, not that you don't have a role. Any injury, anything?
Injured party is not. But TI period has conducted. TI period has conducted.
TI period is conducted.
Yes, madam.
Identified.
You are the informant, and he visited the complainant several occasions.
Give me the CD. Give me the sheet, I'll pass the order.
Yes.
I'll pass the order. Custody since?
5925.
Five, nine?
25.
Yes. Next.
26.
May it please. Lordship, here the petitioner is in custody since 3rd of February 2026. And my lords, as in this case, the allegation is regarding suicidal hanging. On the last occasion, your lordship sought for instruction whether the door was locked from inside or not.
Who are you?
I'm the mother-in-law. In the meantime, charge sheet has been filed and I am submitting the one.
Charge sheet file on?
1 May 2026. 1/5/26.
Yes. What are you showing?
I am lordship.
Anyway, it is now fine. Yes. What are the allegations against the
I'm showing the 161 of the eyewitness.
It is in
reached first.
So, my lordship, a petition is a lordship mother-in-law of the deceased lordship. Petition mother-in-law lordship. Offence on section lordship 80 34 of BNS lordship. 304B corresponds to B 34 of B. So the allegation there lordship due to
CD is there?
Yes.
Yes.
Allegation there due to dowry torture of the petitioner along with the husband lordship, she committed suicide lordship. Cause of that lordship.
You are the mother-in-law?
Yes, lordship. Cause of that due to asphyxia antemortem hanging lordship.
Custody since?
Custody lordship 18/3/25.
18/3/25. Okay. Yes.
Charge sheet
What is
also.
the case? What is the state?
My lord, I'm placing the statement of Arpita Deep. Her statement recorded under section 183 BNS.
She bolted the door after you were physically assaulted her. She went inside the room, bolted the door and committed suicide.
After marriage lordship, the petitioner, no, husband and deceased both are staying in the separate room.
They are staying separate, but the relevant date, the mother-in-law had gone.
Assaulted her. Because that this witness has seen that she was bleeding.
Another statement lordship, one Saluk Barik lordship.
Okay, we'll see. Least after vacation. Yes. Next.
28 Miller, no. Here Miller on the acquisition of possession of 21 kg ganja by 3%, and all three are Miller outsider. And in last occasion, my
Affidavit filed.
Affidavit though filed, I am praying one day time.
We filed the affidavit pursuant to the order date 2/5/2026. Affidavit has not been filed. Comprehensive affidavit is not filed. Mr. Ponda seeks 1 week time to file the same.
I will prepare the affidavit. Tomorrow I will file.
Copy of the same be supplied to the State Council, who shall verify the same and file a report thereafter. Lease the matter after vacation. Yes.
No, Miller. In the meantime, yesterday, Miller, last week, 2 out of Akut.
No, but they have to verify outsiders.
At this
They
juncture,
will have to
yes, no.
go to Bihar and verify.
No, Miller. At this
You should
juncture,
have filed. No.
may I pray one thing, Miller? I file Miller by tomorrow. Let it be learned in trial court after verifying the same release the
No. This is very clear. When
So
it
that-
is rejected again, you will come.
Then
You
verify kari consider man release the petition.
Verify and consider on merits. Release kar.
Because of Miller, my anxiety Miller out of 3, 2 already released.
Parity also has record. Ground of parity is also has record.
Trial court with the level.
Pursuant to the order dated.
No, Miller.
2/5. I'll record it and you will get parity and you will be released. Unnecessarily don't wait.
No,
It will never
Miller
come.
trial court
Then
37.
it will come again. What is it will be?
Then in during list tomorrow file kar debi during vacation.
Better would be that at least you invite an order so that the moment you file it, it will be listed.
During ମୁଁ କାଲି ତ ଫାଇଲ କରିଦେବି during vacation Miller.
They have to
ଯେବେ ବି ଆସିବ
verify.
ଆସିବନି Miller
Verify.
ଯାଏ.
has not been filed. It will be the after verify and release the matter during vacation. 20%. Yes. 29.
Yes. Petition is in custody since 18th February 2026, my lord.
So this was added to after vacation.
In the meantime, co-accused laid down.
No, that's right. But since it was adjourned to after vacation, how this matter has come?
We have filed a memo for but the present petition has two criminal incidents. That the person that they were released on bail. More
More किछ नहीं.
ना यार इंसिडेंट अछि
अमन मेहरा
जो धीरज साहब
धीरज शाह.
ए रिपोर्ट अंश नहीं कहले कम किया
See, that's the problem. You would verify.
My petition अमन मेहरा. He has not.
86 में इधर.
हां
86 में इधर.
The fact is that they are college students.
595
College student means doesn't mean that they
Only allegation that they have let their account to be used for some pecuniary benefit. Apart from that, there is no allegation.
आपण गोटा अमन भाई
Aye.
Just see.
The
Then
main component is
give me.
in fact, they have
one see अमन भाई को
Just see.
but he has not been taken into custody in that.
I say, why are you making wrong statement there?
He is not an accused.
First of all, you say that none of you have been. Now it is discovered that both of you have it.
No, that's it. He is not an accused.
You repeat the bail plea
Where
there.
may I observe that?
And parity and verification of the
Verification of it. May I bring a list?
वेरीफाई बाय हेरिटेज
हाँ?
वेरीफाई हेरिटेज
नहीं चार्जशीट पर होता नहीं है
ना चार्जशीट रे ही वेरीफाई की अछि
नहीं से आरोप
अमन मेहरा
आरोप
आठोड़ा पीएस केस नंबर 577
नहीं बुझना आरोप केस रे तार चार्जशीट
Okay, you repeat. Change circumstance. Right on. Petitions are agreed by the order. Petitions are agreed by the order date. लेकिन जो दुई जगह अलग अलग order इतो by 23/3/2024 whereby the trial court rejected the bail plea. Bail plea. We are equivalent to the petitioners drawing the attention of this court to the order dated 13/5/2026 passed by the coordinate bench in bail appeal number 4305 of 2026 submits that to the co-accused persons Rosengiri and Rosengiri and one Chandan has already been granted bail. They are seeking that in view of the aforementioned change of circumstances, liberty is granted to the petitioner to renew their bail plea before the trial court. The trial court shall, if such application is moved, the trial court shall consider the ground of the authority and by verifying the anti-dismissal law. Yes.
after verification
Yes. Yes.
Sumit sir has no answer, my lord.
That I have written. No problem. It shall be released on bail. Yes.
NDPC NDPS Act, my lord. 32 kg of ganja, my lord. 3 accused. 32 kg of ganja, my lord. 3 accused.
How much?
32.
32 kilo. Yes.
Charge sheet already filed. The petitioner have no antecedent, my lord. 3 accused persons are there.
well earlier bail application of the petitioner was withdrawn on 4th to 2026
Yeah,
final they are submitted on 21st December 2025
20 for 21st?
4/2/2026 रे earlier bail dispose of ହେଇଛି final pair submit ହେଇଛି 21/2025 so that is after submission of the final pair so therefore there is no change in circumstance.
Why did it change?
Well, charge sheet already filed, my lord.
Charge sheet is filed, that's right.
That's December 2025
Hmm.
and last bail application of petitioner was rejected before this order got on
Withdrawn.
2026.
No, that is withdrawn after framing of charge. My lord. The rejection order was prior. Rejection order was prior to the filing of charge sheet, my lord. That's why we have withdrawn and filed after charge sheet.
No, no. Charge
नहीं.
जेहेतु चार्ज शीट हेई साइछि
Charge per after vacation. ठीक, next.
31
Requesting your lordship to list this matter after vacation.
After vacation. Request.
32
May I please, Your Lordship? My lord, this is a case wherein 6 months after an FIR is lodged, alleging that there is 326G, that is amounting to setting fire to the house. 6 months after. The reason is my brother has been killed.
Last time you were directed to verify the
Listen,
affidavit.
verified, my lord.
Yes.
People have been granted anticipatory bail.
But on spot verification, the police found that I found the door of the house was open and there was no asbestos sheet on the roof of the house. The weapon of offence, one lathi, was laying on the spot, and also broken brick and a broken asbestos. The घरटा totally bombing करी नष्ट भांग देइछ. ते घर छाडी पळैछ ना.
My lord, type the
other the petitioner filed affidavit.
people have been granted anticipatory bail. Your lordship may consider my brother has been killed by this informant's brother, husband and brother-in-law. They are accused persons. I have annexed the bail, the charge sheet.
Your brother means Rajkumar's brother or?
That is your lordship, Trilochan Cox's brother. He is one of the.
No, you said your brother.
Yes, my lord. Trilochan
brother. You are the two petitioners. Rajkumar Saraf and Niranjan Kali.
Trilochan Cox. Trilochan Cox is also one accused person. Trilochan Cox's brother.
It's a different story.
My lord. He is also one of the accused persons. That I have filed the affidavit, your lordship. I have stated that after the murder case has been lodged, they are filing cases after cases 6 months, 7 months after.
Where is your affidavit, comprehensive affidavit?
That is your lordship 8/5/2026. 8/5/2026.
Where have you said that? How
My lord. That is the paragraph. And on similar footing, bail has been granted to other accused persons. Same another case lodged 6 months after. They were also having 8 and
antecedent. In this case, any co-accused granted bail?
Anticipatory bail, my lord.
So
that is your lordship.
Role attributed to them
Page
and
20.
role attributed to you are same.
Yes, my lord. Page 20.
Anticipated bail.
Page 28.
28.
Page 28.
Yes.
My lord, there is allegation that all of them, Trilochan Cox, Vicky Cox,
and
Ankita Tandia and other accused persons, there is allegation that all of them went in a mob and set fire to the house. My lord may consider why a person is lodging FIR 6 months after without even stating a single line for the reason of the delay. Even in Honorable Supreme Court in Lalita Kumari case said if an FIR lodged 3 months after.
Anticipatory bail was granted because Trilochan's brother was killed. They
My
see
lord.
the order.
No.
Yes,
Anticipatory bail granted
Anticipatory bail, I am reading it that only.
My lord, anticipatory bail granted because
It is submitted by the learned counsel for the petitioner. The same argument is not available to you.
My lord.
Why are you arguing this?
My lord, the anticipatory
Because your
granted
lordship.
because he was not present. On
No,
analysis
that
of
is not the
above
thing.
cited CDR, as per the CDR, it found that at the time of occurrence, FIR named accused person, namely Vicky Cox, Trilochan Cox, were not present at the spot. After during investigation, police found that even if there is allegation against that those person, but they are not present. Therefore, considering this aspect, granted anticipatory bail.
May I submit, my lord?
So far, the present allegation.
Let him complete. Let him.
After murder case, he has number of FIR against.
Yes, your lordship. That is.
Let me. So far, the kind happens to the year of the FIR, my lord. Starting from which period?
And in the comprehensive affidavit, you have not given any detail, nothing is given.
My lord, I have given. I have stated, your lordship. I am reading, my lord.
Which paragraph? Oh.
Paragraph 7 and 8. May I be permitted to read, my lord? That the petitioner respectfully submit that the conduct of the informant and informant group is very clear to implicate the present petitioner and relation of the deceased Babli Cox in all possible manners, so that the petitioner should be deprived from pursuing the murder case. That is Sundargarh PS case number 5/5/1/2025. This FIR is lodged on 23/6/2025.
Where have you disclosed your antecedents? That's what
My lord, that is paragraph 8. I am reading, my lord, that under the above circumstances, the petitioners even do not know the FIRs lodged against them by the informant and informant supporters. मैं custody रे थिला वाले आगे FIR भी दिया है जी. 2-3 cases.
These are the
There are cases after that.
23 and all.
They are
20, you don't know.
No.
In the FIR regarding PS 2020 case also you don't know. 23 also you don't know.
There are 3-4 cases after 23/6/2020.
This affidavit is misleading.
No, I have annexed a document.
Say that 2020, 2023, 21 and all these cases you had no knowledge. 22,
my lord.
If when the FIR was registered here, 25.
23/6/2025.
Just see the numbers.
I'll get those numbers, your lordship.
This
I'll get this.
affidavit is completely misleading affidavit.
No, I have annexed the documents which I have. And one more thing, my lord, this criminal antecedent itself may not be a ground.
The petitioner has filed an affidavit dated 8/5/2026, inter alia, making the following amendments. Para 8 of the and State Council has produced the CD. From the result of the CD,
That I am getting.
the result of the CD reveals that petitioner number 1 has 14 cases.
8 cases.
8
and
cases.
two have 15 cases.
15 cases. 8 cases, 2 has 15 cases. 2 has 15 cases. And the cases against these petitioners have been registered they are involved in all these cases since 2020 onwards. But contrary to the aforementioned disclosure, then the petitioners have filed affidavit stating that they have no knowledge of any cases registered against them. This statement of the petitioners seems to be completely misleading. Be that as it may, the copy of the list of the cases in which the present petitions are involved has been supplied to the counsel for the petition. He has filed a fresh affidavit disclosing the status of all these cases. All the cases, the same to verify with the state and release the matter on some after case. Yes. 33.
My lord, this is your lordship is calling after vacation.
After. Yes.
May I pray, my lord, one thing? Your lordship may grant me the liberty to move during vacation. I'll file the affidavit.
Liberty is there. Okay. I'll give you. File the affidavit, let them verify.
Your lordship,
Misleading, you are not entitled to bail, I am telling you.
may I submit
Because of
my,
that statement.
my lord, may I,
could have rejected. I am keeping it.
My lord.
Otherwise, I would have rejected.
may I submit only one thing, your lordship?
I'll do one thing. I'll reject it, giving you liberty to renew the bail. There in trial court.
No, may I submit, my lord? Your lordship has been kind enough to grant me the time. I'll file. The difficulty is that we are not.
No urgency. You, in view of the misleading statement made by the petitioners, saying that I don't know anything about any cases, which is registered in 2020 onwards, 14 cases. On the basis of that, I have to reject it right now. So no indulgence at all. If you want, I can give you liberty to renew the bail plea there before trial court. In changing circumstances, you do it.
No, let me file the affidavit.
File the affidavit.
Only prayer is that if liberty could be granted, I can move it during vacation.
Yes. 33. Yes,
please
sir.
Modification of additional condition which is imposed by my lord.
Which condition?
My lord V.
Unnaturally.
She shall be released on bail subject to verification of similar type.
Have you disclosed?
No, I have not disclosed in the bail application, but in my IA I have disclosed at para 3, my lord. The TR number 220 of 2025, pending in the court of the ADJ 2 Bhubaneswar, which is registered under NDPS. Actually, more than one antecedent. Subject to verification.
In the petition, have you disclosed? Have you made any statement before this court that there is no criminal antecedent?
No, my lord. On that date, my lord, 3 bail petition was before your lordships. Your lordship, 11 kg contraband ganja has been seized from 3 ladies. Therefore, my lord has granted bail subject to verification of criminal antecedent.
Where have you disclosed? Where have you disclosed? You say?
In IA, my lord, present IA 356 of 2026, para 3, my lord.
Why earlier you have not disclosed?
Earlier, my lord, due
Earlier,
to,
let us see.
my lord,
Misled or not?
due to mental stress, she could not be able
Mental
to.
stress. No. I just want to know whether you have misled this court or what. Have you
No.
made any statement here? This will be totally duplicated from floor. Petitioner by way of this application, petition seeks a modification of the order dated 21/4/2026. The where is the IA? Copy of the I is not there.
356 of
Copy
2000.
to I, copy to. How these matters are listed without the copy? How it has come now? I have filed but actually released me there.
There, my lord. 356 2023.
Can we?
Flag J.
Why is there? But there is nothing. Yes, it's there. Yes, flag J. There is no flag. Where my the petition although it means on bail, however, with the commission number 5, subject to petitioner has removed this application inter India disclosing that the petitioner he is involved in
TR number 220 of 2025.
one case being TR case number 220 of 2025 pending the court of ADJ to Bhubaneswar. And in this case also it's regarding it to the reasons and regarding it to the governments made in the applications and the remaining stage of thereafter, the same is allowed. The condition is modified, and the condition number 5 to be replaced by the following. The petitioner be released on bail, subject to further verification. Yes.
Yes.
34.
And Your Lordship, Your Lordship, inadvertently, I could not file the requisite on time, Your Lordship. I may be granted one more day to file the requisite, Your Lordship.
Notice was issued to the opposite party number 1 and 4 by the dated 1/5/2026. However, the requisites have not been filed with the petitioner. And the issues one which I granted is the matter up in the month of July 2nd. Yes. Ketra 35.
May it please your lordship.
Yes.
On the last occasion, there was a direction by this honorable court that the parties may remain present because out of 25 lakhs, I have paid 10 lakh 50,000. There is an understanding that the complainant will withdraw the cases after that, but not a single case has been withdrawn. So 14 lakh 50,000 the check has been paid.
Total amount is
25 lakhs.
25 lakhs.
10 lakh 50,000 I have paid.
10 lakhs 50,000.
My lord.
Paid.
And there is an agreement that the cases, arbitration case was there, another criminal case was there. Those cases.
Yes, what do you say?
My accused is also accused is also present, your lordship. Your lordship directed.
You have to pay the money, he has to withdraw the case, as simple as that.
The
How
other
will you
cases.
pay, when you are going to pay, you tell me.
That is your lordship, he is there, your lordship.
Yes. Very deep.
No, he is there. He is there, your lordship.
Arbitrator from Bharatpur, it was.
Have you entered into the reference or not?
No, because he did not put.
Acha.
The arbitration was in the Rohit.
Arbitration is not proceeding then.
No.
Arbitration is not proceeding. And what about the other?
Other case, that is not the. Jahar jinke thila jinke office. There is no proceeding. 14 lakhs 50,000 is the check. That is what for the one CC present one.
I am reading only one line, your lordship, in the agreement, paragraph page 15, one line. Paragraph 5, page 15. The claimant has to take steps to withdraw one CC number 100. Paragraph 5, page 15.
Claimant has to take the steps to withdraw the.
Withdraw one CC 143 of 2018. in the file of SDM Barampur from 2/4/2019, the claimant has also to withdraw the arbitration 31 of 2019. And my learned brother is saying, I am clear of the facts. After I paid 10,50,000, even this CC case is not withdrawn. Now every case is pending. If Lordship may decide, we have to argue the matter. If that is if the complainant will not withdraw a single case in spite of almost 50% of payment.
Yeah, where does it, the other remaining amount, what was the stipulation?
Yes.
Remaining amount to be paid by?
My lord, that is
Para 3 was
Para 3. Today, the executant is paid 2 lakh rupees. And of the total amount of 25 lakhs, the executant shall have the liberty to give the remaining amount of 23 lakhs in part or in full at the end of the above stipulated period. What is the stipulated period?
Just preceding paragraph.
Yes, executant claimant will settle the dispute under the intervention of counsel, and the executant has agreed to give 25 lakhs within a period of 11 months
11
from today. So in case the so executant so this agreement was entered into
23/3/2019.
19.
Thereafter, I paid your lordship 8,50,000. I arranged and paid 2 lakh on that date. I paid.
And thereafter, when you paid the next amount,
but that written is got a flat kinle, so adjustment is that is admitted fact. 8,50,000 thereafter I paid. I showed my bona fide, my lord. He should have shown his bona fide by withdrawing at least one case.
okay. You remaining 13 lakhs.
14,50,000.
14. How much you will pay? You tell me.
Now
Give the first installment. He will withdraw the
other ones.
The 1 CC case, and the second installment, the arbitration. I'll fix the dates. You tell me.
that your lordship I have to, because he was there. I talked with him. He's saying that now because of this COVID and financial bankruptcy, he is unable to make a statement before your lordship. The situation is beyond his control. I have never.
Then you have to find out the way it will be withdrawn, no problem, because nothing is proceeding. As per his statement, nothing is proceeding. All the 3 cases are stalled.
1 CC case has been sent to police. It was registered as a FIR, Baidyanathpur case number 45.
Everything is stalled because of the settlement. The settlement is vague settlement. Completely vague settlement. What is this?
That the party
So anyway, you have agreed, nobody can question it.
My lord, the
But
parties
once
have
you have
acted on-
agreed, but you have to, you show some bona fide. How much you pay? You tell me. At least some amount.
That your lordship may keep it to tomorrow, day after tomorrow. I have my number.
Tell them come with it.
No, if my
केवे दे पेलू कौन थी? किस दे पेलू? केवे दे? नीर कोई कौन बोल सुने अपना? हाँ? कौन सुने अपना?
Is son of the.
But see the financial condition of this man. What to do?
How can he say like this? Absolutely not acceptable, your lordship.
All right.
I understand his element, but that.
It's all right. You lawyers are speaking like that.
Any term and your lordship, that is, I remember that. But may I pray, my lord? I am making a prayer, my lord.
They are local people. They must be knowing each other.
I am making a prayer, my lord. I have my brother's number. Let it come on a date. If nothing would be finalized, I will press my matter on merit, your lordship.
On the merit, what you have?
On the merit, it is returned that you contact the drawer and draw bank present again. The check bounce case is not maintainable on that. That is not on insufficient ground. I have got judgment on to that effect.
Show me. Let us decide this application.
Yes, your lordship. Take care again. Here the check was not returned for insufficient fund. It was returned to contact the drawer and present again. He should have presented it again.
It's a very short order and it has been quashed.
Yes.
I'll find out if.
Yeah, tribal issues.
Yes, this is the issue, Your Lordship.
Show me which part.
My Lord. Paragraph 2, last line. Kindly contact drawer. Paragraph 2, last line. Kindly contact drawer Roy Bank and please present again.
Yes.
My Lord. Then it was contended that whatever may be the ground of return, check bounce case is maintainable. Whatever may be the ground of return.
So para 5.
Para 5.
The only ground.
The only ground that has been raised by the learned counsel for the petitioner is that the check has been returned by the bank by requesting the respondent to contact the drawer Roy Bank and present it again. The respondent, without complying the requisite, has proceeded to file the complaint of an offence under section 138 of the NI Act. It is true that the Honorable Supreme Court of India has held that for whatever reason a check is returned, a complaint can be maintained under section 138 of the NI Act, and if such a purposeful interpretation is not given to the provision, it will defeat the beneficial legislation which wants to penalize the person who fails to honor a check after issuance of the same. However, in the facts of the present case, the concerned bank has not returned the check on the ground of defect. It has been returned by directing the respondent to contact the concerned bank.
Where is your memo? You show me.
Memo, I have not annexed, but the complaint it is stated.
Where is that?
My Lord. That is page 11.
Yes. Para?
Para 7. The branch manager on 25/10/2021
kindly contact para 7. Kindly contact with the drawer
and present again.
Present again. Memo, show me the memo.
Memo ta agya mo pagre nahi memo ta takka pagre thibo. It must be there with the complainant.
Do you have the memo? Show me the memo. I'll reject the judgment. I'll reject the judgment. I'll reject the judgment. You show me any written note of submission you file?
Yes, sir.
I'll dispute it up.
Within 7 days, sir.
Within 7 days, written and along with the memo.
In the description.
And this judgment is contrary to the Supreme Court judgment.
I have gone through that judgment of Honorable Supreme Court also. Therein it is stated whether insufficiency of fund is there or not. That is a matter to be verified.
So therefore, it is his headache. It's onus on him to prove that on that day amount was not there. So this is a tribal issue. What is the stage? This can be what is the stage of this? Give me that judgment. Give me that judgment.
That is quashing a lordship after issuance of notice. Same stage like me. And Honorable Court was of the view that he should have presented it again instead of filing a complaint directly. Thereafter, your lordship, he can do that, but he should have presented it again.
What is the 130 notice has been given to
My
you?
lord.
Payback. You should have paid. Presumption operates thereafter 139 presumption.
Not binding, but it has persuasive value. I'll produce other judgments also. Same effect.
Written note of submission, both of you. Give me, I have reserved the judgment. Okay. Reserved. Otherwise, this will go on and on. Nothing. You are not going to make any.
Within 7 days.
7 days, you go. No problem. And one dispense. Yes.
Along with citation.
Along with citation and the relevant paragraph also. You show that. Yes, 36.
36. Please, Your Lordship. My Lord had heard this matter on the last occasion. It's a quashing of the NI Act proceeding. Because the check has been issued by the company, Your Lordship, at page 9, Your Lordship, the copy of the check. And the company has not been made a party, neither any notice was issued to the company under section 138. Page 9 is the copy of the check, Your Lordship.
Visual acute information taken was.
Yes.
My Lord, before my learned brother submit, may I submit, my Lord? This CRLMC may not be maintainable because there is judgment, there is an order by this Honorable Court in CRLMC 390/2016 at page 32. 32. Wherein it is accepted that since the company has already been made a party, let it be proceeded. There is already an order, my Lord. My Lord, Honorable Chief Justice has passed. That is page 32. CRLMC 390/2000. What has happened, my Lord? I filed a petition for amendment to add the company as a party. It was allowed by the learned session judge. Thereafter, 390/2016 on 23/9/2022, when disposed of, that order was already there. Honorable Court said it is already stated that the company has since already been made a party, then it is to be proceeded. Now he is saying again the same thing.
Leaving it open for the petitioner to raise.
Yes.
Where is that? We stated that.
Page
the company
32.
Has since been added.
Yes.
As a party. What to do?
Yes, that is an, he has to challenge this order.
Have you challenged?
Yes.
That is what I am challenging the order.
No, again, man.
In a parallel proceeding, how can you challenge?
Yes, your lordship, that is exactly not.
Let me move. Yes.
My lord, that is what I am challenging the order of the learned sessions judge, because I was not made a party before the honorable sessions judge and the order was passed. Under section 4012 of the CRPC, the proposed accused has to be made a party, which the company was not made a party before the honorable sessions judge. The 319 petition, which was rejected by the learned JMSC, that was allowed by the learned sessions judge. And when the director had...
Now, fact remains that now the company is now a party.
Company,
Yes.
that order of the learned sessions judge, I challenge here, because I was not made a party there before the honorable sessions judge.
It cannot be, my lord. In 2019, the honorable sessions judge passed an order. 2022, my lord is passing order. He is saying director is there. Director is there.
What was the stage when you were implemented?
Check, my lord.
No, company is implemented. What was the stage up to the complaint?
That is issuance of notice only. From big, he is prejudiced.
Evidence was not
When
there.
2019
Notice was issued, cognizance was taken.
Keep it open for.
Yes, my lord.
My lord, may kindly see
Final stage.
the
Yes, yes.
order of the learned
That is
sessions.
Keep it open for the.
My lord, for a minute. This I have a exactly judgment on this ground. Exact similar case. Rather, my case is on a better footing, where the 319 petition was allowed by the JMFC. The Honorable High Court confirmed it, but the Honorable Supreme Court held that it cannot be done.
No, that I do not deny. Let him challenge this order.
I challenge that order.
No, how can in a parallel proceeding it can be challenged, my lord?
That is the whole difficulty with you, that the order dated 23/9/2022. And para 3 says that it is open to raise all these things at the
Well,
appropriate stage.
in that case, the director had filed. Now the company has filed this petition because I was
Company, my
not
lord, that these pleas if taken, company is represented by director. He knows everything.
different, and this is a squarely.
No, I do not dispute, my lord. This case wants to challenge these orders to the honorable supreme court.
See,
I cannot say anything.
Okay, which paragraph?
Paragraph 7, your lordship, it starts from that. According to the said application, it came to the notice of the respondent during the course of cross-examination of the appellant that the trial number.
That is at the stage of cross-examination.
Yes.
My lord, that is the much after.
So, your lordship may kindly see the operative portion. Your
It
lordship,
is only the lordship
see the operative portion of the.
taken money from.
I think one at a time will do better.
It is only a lordship fraud.
Hearing both.
I have paid my
To
entire.
hear one mind. The problem.
I have paid, my lord, my entire amount.
You are showing the judgment.
My lord, para 25, your lordship.
25.
My lord. The question whether the respondent had sufficient cause for not filing the complaint against Dakshin is the company. Within the period prescribed under the Act is not examined by the either courts below. As rightly pointed out, the application, which is the subject matter of the instant appeal purportedly filed invoking section 319 of the CRPC, is only a device by which the respondent seeks to initiate prosecution.
319
Yes.
was issued. That's a different story.
In our case also 319.
Application was moved.
Yes.
That are wrongly stated.
Tell me one thing, whether 138 notice was given to you.
No.
So you have a very clear case. You will be acquitted. You can't be convicted.
My lord.
Keep it open.
My lord,
And
kindly
not a
see.
statement that 130. See, without issuing 138
Yes.
statutory notice under 138(2), even if you are made party,
My lord.
then you have to be
Yes.
acquitted.
My lord,
As simple as that.
Yes, my lord, the cause of action doesn't arise to file a complaint against me because under section 1.
That is the argument you have to advance at the stage, appropriate stage. That is the observation made by the coordinate bench of this court.
My lord, because my lord, that was an ex parte order passed by the Honorable Sessions Judge arraying me as an accused. I'll just place your lordship.
Why the company has not challenged this order?
My lord, sorry.
Could have challenged. It was open for
Which order, your lordship?
the one passed by the coordinate bench.
My lord, company was not a party before the Honorable.
Therefore, you should have moved to the Supreme Court.
Because company was not a party.
Therefore, you
My
should
lord.
have gone.
My lord,
Permission to challenge.
I have challenged here two orders. One of the Honorable Sessions Judge under 4012. My lord, without arraying me as a party, that order is completely null and void.
File written note of submission.
My lord, I'll also file a judgment, recent.
I'll also file a judgment.
My lord,
I'll also file a judgment, your lordship, squarely covering my case.
25 Jamin versus State of UP.
relevant paragraph and file, and you please file the 138 notice also.
Yes, sir.
Notice.
The statutory notice which was
My lord.
issued by him, not to the company, but rather to the director.
Only the
There is the judgment, my lord. If it is served to the managing director, not in the personal address.
Whatever you want to file, judgment is.
My lord.
Yes.
Your lordship, the same 7 days time maybe.
7 days time.
Well, obliged.
Yes.
37.
37, your lordship, I have very less to say. I am for the petitioner.
Settle.
No, it is infructuous, your lordship. Say, I do not have any contact.
Counsel for the petition submits that
Upon
38.
38.
Like,
May I please, my lord? In this case, my lord, petition of very limited grievance, my lord. 205 petition has been rejected, my lord. Where the petitioner staying in Hyderabad, court, my lord, may Rayagada.
What is the offence?
138 only, my lord. My lordship, Hyderabad से attend करियो ऐसे कि रायगढ़.
What is the check amount?
Check amount of 4 lakhs.
Small amount money, 4 lakhs only.
You will spend more money. Why don't you pay?
Let them sit and compromise. Let it matter.
ସେମାନେ ମତେ 205 ଟା allow କରିଦେଲେ ମୁଁ ତା କଣ କର ଗୋଟେ ଆମେ
It is allowed, then you will never come. You will never pay. Better sit together and do it.
ମୁଁ ତ ସେ କଥା
And a manufacturing unit. They promise to
4 lakhs with installment.
my lord तू से जरी के
And once you come,
my lord
then you will spend more. Where is the case going on? Rayagada.
Rayagada.
And
I am from Hyderabad.
Hyderabad. Then at least you will spend 20,000-30,000 rupees coming. That will suffice for installment.
That plea was taken by the taken by petitioner in the court below. But court below rejected my 205.
Summons were issued. The deliberately availed to appeal. Finally, after issuance of NBW, they filed 205 petition. That has been rejected.
NBW will stay.
No stay, nothing is given.
No. NBW, I will cancel the NBW. He will appear.
Yes, never.
He will appear, and first day it will be sent to mediation.
Yes.
Thereafter, you have a right to move application. First day you have to appeal.
Yeah, no,
Petition
not
is
by the
agreed by the order dated 4/12/2023. Where is that order? 4/12/2023.
That is page 16.
Whereby is the application under section 20.
एवढी टाकी my lord lots of permission. आपण high court settlement टाकी my lord lordship.
It will be much more expensive. You appear on the first day. I give
आम्ही लगे high court advocate किस पे settle लाभ the by proof track में लाभ चलेंगे. If lordship will
Lordship fix a date. By that date, he will appear before the lordship. At least pay 50%.
क्या कौन? कल मुझे प्रेयर करेंगे इम्ति करियो कौन?
What I am proposing is, I will direct that you will appear on particular day as per your convenience, and on that day the trial court will explore the possibility of a settlement, and thereafter you have a right to move application.
So for the NBW lordship class.
NBW like class.
Class content to I get a class content.
High court करियो ना हमें कौन?
NBW annex by now.
कर दो
Has been
Yes, never challenge the NBW.
rejected.
यार हाई कोर्ट रे पार
When is the NBW issued?
से कोजन को
You further submit that to pursuant to the petition.
But lordship may see.
Tell me the date.
Order reflects, but he has never appended.
Give me
that
the date pursuant to
Date has not been
the order dated 4/12/2023.
सही तरह से कॉल
whereby
करेंगे.
the application info not dated so and so, where his application has been rejected. Application under 205 was rejected. The trial court has also issued the NBW. Date you don't know.
इतने मेंशन कराएंगे.
Over the counsel for the petitioner is now able to disclose the date date on which the NBW is issued. Mr. Das and counsel for the respondent submit that even summons are issued to the petitioner after even after receiving the summons. The petitioner has not appeared before the trial court even for once, taking into consideration the one CC case initiated by the respondent has been pending since 2022 regarding it to the submission made by the counsels of the party, and taking into consideration the fact that the complaint is pending since 2022, suffice to say that the petitioner shall appear before the trial court on or before 5th of June. on or before 5th of June and 5th of June. Bailable offence is 5th of June. The trial court on his appearance shall send the matter, shall make an attempt to settle the dispute through mediation, mediation. And it is also open for the, if the dispute is not settled through mediation, and the trial proceeds at the appropriate stage, the prisoner has legally to application under 205 for CRPC. If such application to you, the trial court is at liberty to decide its on merit. The NBW
Date, my lord, he has not mentioned, my lord, particular lordship may NBW, if in NBW issue, my lord, my friend is saying, or does it also say so?
Unless you say that
Not date, the impugned order lordship dated 4/12/23, only they have stated NBW has issued.
NBW stated to have been issued against the petitioner pursuant to the order dated 4/12/2023 shall not be executed. Yes. In the meantime, yes. With these observations, petition disposed. Yes.
39.
Again, in the procedure for enactment, I am challenging the order dated 30/10/2023. The complaint petition has written by the court below on ground of territorial jurisdiction.
Territorial jurisdiction. Yes.
When the case was in 2018, the order was passed in 2023 after examination of the witnesses. But as per the provision of the Amendment Act, it is clear secretary has transferred to the territorial original jurisdiction. Without transferring this time, they returned. The case was listed to regularly in Lok Adalat and also this.
Where is the court? Original jurisdiction court?
Original jurisdiction Dhenkanal Goinda.
And this is
case was pending SPGM
Dhenkanal. District court can transfer it.
Yes.
Same district.
Same district. So the amendment of provision to 2015 amendment, sir.
138. What happened to the respondent?
Respondent as soon as the Lok Adalat will asking, maybe Adi action.
Which provision yours?
42A. 42A, man.
42A. Release of transfer of pending. Not recently anything containing code of procedure condition or any open. Transfer to the okay, I'll pass the order. Pass over. After you will pass. Huh? 42. I'll pass the order.
Yes.
Yes. None appeals for the opposite party despite Mr. P.K. Maharaj was there. State attorney. Status service position. Opposite party number 2. Yeah. Already Mr. Ponda is there. His name is reflecting.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
So pass it over. Pass it over. Pass it over. Pass it over immediately after. I just come.
One for 2-3 of 2026. Who accused persons? They are on interim protection, my lord. The case was directed to list on 2nd April. The matter has not been listed thereafter, and they are on interim.
Give the numbers. Give the number. We'll pass the photo. Okay. Yes, next.
My lord, allowing the.
I'll pass the order. Yes.
39.
Proceeding on 138 in that manner.
Yes.
The territorial round, the lawyer magistrate.
Who was appearing for the other side?
142 to.
Nice. Who is appearing for the other side?
Other side, the Astunan.
Opposite party number 2.
Niranjan Panda, the lawyer and advocate is appearing.
Niranjan Panda. Okay. Show me the impugn order.
Page 33, my lord.
33.
Yes, ma'am.
Yes. Yes. Yes.
Both the sides, but the case record, this case is 130 NIR. It appears that the change in question has been drawn on the SBI Sector 11 Martadnagar CDA Kotak. According to the complaint petition, the change in question has been presented before the SBI Joronda branch, Dhenkanal for collection. As per both the transactions has been done outside the court's territorial jurisdiction.
Yes.
And therefore the honorable court orders are cited.
Yes.
And in page 35,
Week of the aforesaid,
in 201, the director returned the complaint to the complainant, presentation same before the proper court.
Now, what is prejudice? It is returned to court.
My lord, in the case, the cross examination completed. The PW examined and cross examination completed. But now we have presented the case, the started in initially. As per the provision, one amendment, the case will be transferred. If the territorial jurisdiction is questioned, those are transferred to the original jurisdiction, my lord.
You are
142 A, my lord.
Clause?
Clause 2.
Clause 2. Not restraining anything containing section 2 of section
1, 2, 3, everything is the transfer, my lord.
Which provision? 142 capital A.
Capital A.
Yes. Read it.
Notwithstanding substantial clause 1, my lord. Anything containing the code of the criminal procedure, the order and direction any court, all case transport to the court having jurisdiction on subsection 2 of the 142 as amended by the Necessary Instrument Act shall be deemed to have been transported under this act and such session has been forced at all material times, my lord.
When was the complaint presented?
Complaint presented in 2018, my lord. Unnecessary.
When the amendment is?
Amount is 66 lakhs, my lord.
Amendment, when the amendment?
Amendment in 2015, my lord.
If there is multiple complaint, then in that case, this.
There are the complaint cases, my lord. But in my case, I am showing the order sheet, my lord.
All cases transfer to. If there are multiple cases, then in that case, but this is not the case of that nature. Who is the accused? Accused is an individual. It is not a company.
Yes, my lord.
So therefore, how can you apply 142?
No, 42 amendment when the
amendment is also regarding the companies.
No, my lord, in the case 2, the deliver the check to sin.
Show me any judgment in that case.
My lord, in judgment, my lord, the larger bench of the Honorable Appeals Court, my lord, in 2014.
Give me this.
Page para 20, my lord.
Give me this.
If any case in stage of this, how many stage or the case was returned to transport? Para 20, my lord. If a trial is in comments, the case was tried in that court, my lord, as per observation.
No, this judgment is something different. That's what this is operating in a different field altogether. Where does it say that it will be transferred? Return and transfer, because the trial court has rightly exercised that power.
Return the matter, my lord.
Return, that's right. So where you show me right judgment? This judgment is not applicable.
My assumption, if I am filed the fresh complaint petition.
That is not the issue. Issue is if can the court transfer it or not.
As per the amendment, I was shown that it is transferred, my lord.
When an amendment is only pertaining to the company cases, where multiple cases are filed, going on in one case, both the cases can be transferred and tried together. That's the idea of 142 capital. That you can't, apply to this facts, this case. Prepare properly and give. I'll just put it after vacation. Put it after vacation. Yes. On request 40.
I'm on BC Millers.
Yes.
Yes, matter relates to 138 NIAC Millers. Here I am challenging the order of recall Millers that has been rejected by the learned court below Millers on 12/1/2024. Examination in chief was been held. Thereafter, I filed a petition to recall the witness on the ground that the passbook needs to be exhibited as one of the vital documents. And that has been rejected on the ground that already cross-examination has been started and this is the not right time to file the case. On the other hand, no cross-examination has ever been taken place at any point of time.
Yes, you're appealing.
No instruction, my lord. No instruction from my client.
I'll allow this petition.
And he has taken consent from the trial court, my lord.
But whatever, see, 300, see, the PW1 was the examination chief has been done. Cross-examination is not done. Has to be allowed. I don't. Where is that? Where is the order?
Order is at Millers, Annexure 4, page number 22, Millers.
Yes. 22. What order dated? 12.
Order 12/1/24.
Out of the petition filed by the petitioner company. Where is your evidence? Where is your evidence for me?
Yes.
Where is your examination in chief?
Examination chief. So, on the last occasion, your lordship was pleased to call for the. I will produce it, Millers. I have got the copy. Pass.
Give me that at least. Show me the examination chief.
Maybe pass over after half an hour as well.
What pass over? These matters are pending since 2021. I just want to see the examination in chief of the complainant.
Yes, Mr. Right now.
Whether sufficient opportunity was given to you or not.
Yes, please. Cross-examination not been started, Millers. That is my argument.
You are partly cross-examined.
No, Millers.
Partly cross-examined.
No, Millers.
That is what is recorded. That is the reason I want the statement.
Yes, sir. That is recorded, although it has been recorded, but I affirm that
where from I'll get it, sir? You don't file the documents. I dismiss it then.
No, Millers.
What you do? The relevant document you don't file. And these cases are pending since years.
On the last occasion, your lordship was pleased to call for the records. Lordship.
I have not called for any record.
I will submit it, Millers.
I have not called for any record. Only issue notice.
So I will submit it.
Your case, you have to. Why should I call for the record? It is your case, a complaint case. You have to file all documents.
Yes, Millers. I will file it.
I will file it. Then I'll dismiss it and giving an opportunity to file a fresh application.
No,
unnecessary pending.
Let us short adjournment. I will file it.
No question of adjournment. These matters are not here to get it urgent routinely. Petitioner is the complainant in the particular case, who has names for appeals for this question, and so on. So you have no instruction.
No instruction.
You file the Wakalatana.
After receiving the notice, I have already filed my Wakalatana. Thereafter, he had taken continue.
Already filed the Wakalatana on your respondent. However, that means that he doesn't have any instruction in this matter. Rather the respondent has taken no objection, already taken no objection from me. After taking no objection, the respondent, the accused, is not engaged in that one. Next part. The petitioner, by invoking the inherent jurisdiction of this court under 482 CRPC, had challenged the order dated 12/1/2024, whereby his application under section 311 CRPC has been turned down on declining his prayer to recall PW1 for the purpose of addition, for the purpose of further cross-examination, so as to reduce, so as to exhibit some relevant document. It is confirmed by the petitioner that the petitioner, though the trial court has recorded that after the examination of chief, the PW1 has been partly cross-examined. However, in fact, the PW1 has never been cross-examined. The recording of the observation in the impugn order indicates that the complaint property indicates that the complainant bracket PW1 was examined and cross-examined in part on 17/8/2022. Thereafter, the matter is lingering for cross-examination. At that stage, the complainant accused to move the application under 311 CRPC. The present next paragraph. The present case is arising out of a 1cc case filed on 12/11/2021. 2021, and this case is still prolonging, still following. Taking into consideration the facsimile of the present case and submission made by the learned counsel for the petitioner, and on the basis of the available record, I am of the considered view that the petitioner is entitled to a singular opportunity for cross-examination, for reducing evidence of PW1. Accordingly, the application moved by the complainant petitioner under section 311 CRPC is allowed. The complainant is we try to direct to afford the complainant a single opportunity by fixing a particular date for the proper approach regarding the evidence of PW1. It is made clear that in no circumstances adjournment shall be granted to either of the parties, and the complainant shall conclude the evidence of PW1 on the date to be fixed by the trial court. This observation, the petition is disposed of. Yes. Next.
41 was not done. Ending not back from the opposite party.
Sorry?
Item 41. Ending not back from the opposite party. Sole opposite party.
You are appealing for?
I am appealing for the petition. Since the notice has been issued by laws, till they have not yet anything. They cannot after petition.
No, what is this case? Let us see.
Arrangement of 130.
Yes. Yes. What are you challenging?
What is wrong? Maybe taken up day after tomorrow.
See, these matters are pending since, just imagine, and you got a partial stay. It is. And see, I have recorded that you said that the total check amount is 2,50,000 rupees in total, out of which you 50% you have already paid. And to that effect, you would be filing a affidavit within a week. And you have also made a statement that I am ready and willing to make good the entire payment.
Yes.
Where is the affidavit?
They will also keep it to day after tomorrow.
No, you show it is there. Where have you said that you have filed 50%? Once the interim order is passed, then you make all these things. It's relevant to mention here that petitioner has already paid 50% of ownership. So what are you challenging here?
Dismissal. I have filed an application with regard to dismissal of the complaint. That has been rejected.
Where is that order? Where is that order? 17-1, 2024. What have you moved? Petition filed by the cause of the accused of non-transaction to recall the order of Cognizance and reject the complaint. Not continuing the possible interpretation or conducted the government to use one 2 words. By him that
Can fix it? If we have to do it, I'll check this one.
you said that you have paid 50% and now you file an affidavit. Let the trial court decide. This affidavit was not available to with the trial court. Let the trial court decide.
Day after tomorrow.
Day after, you know, day after tomorrow will not reach. That is the reason you are asking the time. Why have you not prepared? See, these matters are specially listed for this purpose.
They have to do
Not to give adjournment. This is a very specific instruction. Not to give adjournment.
I'll satisfy.
I'll pass the order. Whatever you want to say, you file it.
Other, you'll also keep it to tomorrow at least. Tomorrow I know.
Keep it tomorrow.
Tomorrow.
Yes.
Item
43. Yes.
My lord, I have prayed for quashing of the entire 138 proceeding. The reason is, we just bring to your lordship's attention at page 19.
Yes.
The check was issued in favor of Rudra Motors. If my senior my one senior ones after vacation, I have no objection.
After vacation. I have got decisions, but I have not brought it. I have found out some decisions.
Decisions of this honorable court as well as apex court, that unless the company is made a party.
That is there. But later on, some decisions have been there.
That Lalit Beriwal is there. Anita Hada is there. Anita Hada.
And recently,
Anita Hada was the first case.
Yes.
The point. Later on, it has been developed and diluted little bit in 2023, volume 3, SEC Criminal 568. 2023, volume 1, SEC Criminal, page 91. But I will summarize it and see a short note.
But I have seen it also, the statutory notice under 132 is also not filed.
Yes.
You filed it.
They are not given.
देखिए देखिए मुझे वो वेरीफाई करनी डिटेल
File it, you file it.
वे on the opening
Which
minute
all are appearing
both
for
the
the
cases.
opposite party submit that he would bring on record
I was saying so.
statutory notice under section 130 purported to have been issued by his client to the petitioner and the company and the accused company.
Let them produce the original check.
And also original check he might have filed it.
Not the certified copy.
He might have filed in the court.
Yes, let them produce that also because I have.
How will he produce it?
In the court of trial
How will he unless
Obviously.
trial
trial court record of
Certified.
certificate copy
Yes.
enough.
কোড আনলো
So but
ট্রায়াল কোড আনলো না এটা কি জানলো সেটা বেসিস কর
trial court record আনছেন
I am learning. My lord, I am learning from my senior. I will never say no to him.
but there are some manipulation or something I don't know what
Yes.
is
There are 43, 44 both the matters. Why let me fix of 23 or 24?
23 June na
23 or
29
25,
29 both men.
Interim.
But why these manipulations?
Yes.
You see the manipulation.
I'll see to it.
And there is signatures also.
Yes, sir. I'll see to it.
If that is the reason of dishonor, then perhaps you have a very good difficult case.
I'll see to it. 43, 44 both the matters.
Yes.
Interim order in both the
Interim
cases.
continue. Yes.
My lord, may extend the interim order.
Yes. Interim order to continue. Yes.
45.
That copy has not been served on me.
Why, madam? See, the interim order is operating against you. If you don't do it, they'll take benefits. The problem. Now you are giving, see, he's entitled to at least see that. Persons to the order dictators. 1/5/2024. 1 year. Delay is attributable to you only. Notice was issued. You are asked to file the counter. Now you are giving the counter. Then who will be responsible? You will be responsible for dealing of your case. 1/5/2024 notice was issued to the respondent, and it was directed and directed to file the counter affidavit. Unfortunately, the counter has not been filed till date. Then counsel appearing for the petitioner submits that. Have you filed it?
Yes, sir.
When?
Sorry.
That is on record. He has filed before the court. That is on record. But copy to the just now copy.
No, it is already been filed. Yes, that is there.
This is on record.
Filed long way.
Long way.
Without serving copy, you have filed.
Yes. There is serve the copy to the state. They have to file.
State you file karo 130. And notice was issued and the petitioner the respondent was directed to file counter affidavit pursuant thereto. It appears that on 20th May 2024 the counter has been filed, but the counsel for the petitioner submits that the copy of the counter has not been supplied to him as yet. Let counsel for the petitioner has today supplied the copy. We no right rejoinder in view of the same, leaves the matter for final disposal on though it is made clear that no further adjournment shall be granted to the petitioner in any cost, and for the adjournment is sought by the petitioner on the next date of hearing, the interim order dated 1/5/2024 shall be recorded. Yes.
Interim order 1/5.
Yes. Next.
46. Sir, on behalf of M.K. Mahapatra, seeking permission for withdrawal of the matter.
Withdraw. Yes, withdraw. Withdraw. Yes. Next.
47. It's in my lord. I'm praying for an adjournment. Already, plaintiff has been appeared in this case. We want to settle this matter and taken up after vacation, my lord.
Yes, what is
on
We have no objection.
This is
where
where opposite party number 2, my lord.
are you settling the dispute?
Yes, we are going to the, because this petitioner is now undergoing treatment, my lord. We are severely accident. So that's why if you taken up after vacation,
It's just they're approaching us, so let it be after
Sorry?
vacation or take instruction. I can do.
No, not instruction. Then I am sending it to mediation. Do it. If you are settling, then send it to mediation. What is the check amount?
1,50,000.
So I am sending it to mediation. Where is it pending? Baleshwar.
Baleshwar, my lord.
Baleshwar to mediation. No? Baleshwar mediation. Then counsel for the parties conjointly submits that there is a scope of settlement in this matter. The dispute is regarding the design of check of rupees 1 lakh, huh?
1,50,000.
1,50,000, huh? 1,50,000. Regarding to the statement made at the bar by both the counsel, let the matter be referred to Baleshwar Mediation Center and awaiting the mediation report means the matter. Give a date, particular date.
Interim order to be continued.
Interim order, there is no interim order.
Okay.
Yes, next. 48. Mediation Center, it was sent.
Mediation center, report is there.
Huh?
Mediation field.
Awaiting mediation report.
Report is there. Report is there.
Who is appearing? On by the order dated 17/5/2024, the matter on the request of both the counsels. On the basis of the submission made by the counsel for the petitioner, the matter was referred to mediation center. Refer for the High Court, refer for mediation before the High Court Mediation Center. It appears from the report dated 16/8/2024 that the mediation become unsuccessful. Subsequently, the two matter was listed on 28/8/2024. That day, none had appeared for the petitioner. Even today, when the matter is called for, none has appeared for the petitioner. In view of the same, the interim order passed on 17/5/2024 stands executed and will disturb justice means the matter for hearing and so on. So, vacation. Interim order vacated. Yes. 49.
Item number 49, please, my lords. Lords, here I'm challenging the rejection of the section 143A NI Act application, my lords.
Note, service of notice, please. Notice, sir. Fill it up.
Yes, ma'am. Service appreciate.
Who are you?
My lords, I am for the petitioner, my lords, complainant.
Complaint, yes.
Yes.
Your application on 143.
143A of the NI Act.
Rejected.
Yes.
Yes.
My lords, here, my lords, for your lordship's kind perusal, I just want to bring in to your lordship's kind notice the date of summons after 138 NI Act case was filed, after cognizance was taken. The summons was issued back in the year 28th of July 2022.
Yes.
Subsequently, the charge was read over after, my lords, around 8 months or 9 months after that. That was on 26/6/2023. I am saying this, my lords, in order to bring up, my lords, the conduct of the accused on record, my lords. So he has been playing this delay tactic since the beginning. In fact, my lords, if I would like to also bring this on record, my lords.
Where is the proceeding? Show me the proceeding.
Yes, my lords.
Who is responsible? Let us understand.
Annexure 4, my lords, is the impugned order, my lords.
No, you say that 17/6/2026 is the date on which the cognizance is taken.
Yes.
No, date on the which you have filed the complaint.
Cognizance was taken on
28/7.
Yes, 28/7 summons was issued, my lords. Cognizance was taken and summons was issued, my lords, on 28th of July 2022.
When you filed the complaint?
Complaint was filed on 17th of June 2022.
Okay.
And there is also, my lords, it's a weird catch is there, my lords, how the trial court has, my lords, misconceivably has recorded
These are not
140.
the issue. Just show me why
Yes.
your 143A is rejected. Grounds
Yes, my
first.
lords. The lordship may kindly come to
Yes.
page number 24.
24.
Yes. Annexure 4. On 3 grounds, basically, the Honorable, the learned trial court has rejected my case, my lords. The last 5-6 lines, your lordship will see on perusal of the case record, it seems that, did your lordship get it?
24.
Yes, 24. Last paragraph after 4 lines, my lords. On perusal of the case record, it seems that the accused has appeared before this court in obedience to summons issued to him and has not sought unnecessary adjournments in vexatious intent. The conduct of the accused cannot be seen as negative, and any order for payment of interim compensation may linger the trial proceedings. This is first ground. Second ground is the complainant has not submitted any documents to show financial hardship faced by him, which qualifies him to seek interim compensation at this point of time. And third is, in fact, the petition for grant of compensation was filed on 17/6/2022, much prior to appearance or reading of particular to the accused of the offence. Malats, the conduct of the accused is crystal clear. Malats, the fact that after so
What is
many
the stage of the trial now?
Malats, the witness of the complainant has been examined, and after 3 months, they are filing a 311 petition for recalling of the same witness, the accused. Malats, in view of the standing order of the Honorable Supreme Court, this matter was also referred for Malats compromise. Twice or thrice, they did not appear. In this Honorable Court also, twice it has been listed. They did not appear despite the fact it has been made sufficient, Malats. Notice is sufficient to them. This shows their conduct, Malats. This shows that the very intent of the legislature that the amendment was brought into force has been defeated.
So what is the prime ground? Prime ground is that you move the application prior to the cognizance is taken.
Malats, I went through the provision, Malats. The provision is very loud and clear about the fact that the court may pass orders after the charge is read over. It is not mandatory that we have to file it within a certain period of time. And we have filed it. Malats, the court has wrongly recorded here. It's not 17/6/2022 as the court records here. 17/6/22 is the date when the 138 NI case was filed. 143 was filed on Malats 21/6/2023, just 4 days prior to when the charge was read over. We did not press for it at that point of time. After the charge was read over,
why don't you repeat your application?
Malats?
Why don't you repeat your application?
We can do that, but Malats, it's been.
Then who stops you? I'll give you liberty. Move the application.
Malats.
This ground goes. I'll set aside this and give you liberty to move fresh application. If that is the only ground, the application, in true sense, the trial court says that the application was premature.
Lordship may set aside this order. Malats may give liberty. I'll file another.
That is what the language.
Yes. Malats.
Petitioner is agreed. Petitioner is the complainant in the 138 NI case initiated by him against the respondent. The petitioner is agreed by the order dated. What is the order dated?
Malats, the order is
15/11/2023. Whereby his application under section 143 capital A1B of NI has been turned down. This court issued notice to the respondent by the order dated 28/6/2024. 24. Though the service is sufficient, but none major appearance. In the meantime, twice it was sent to mediation.
Yes.
In the meantime, counsel Mr. Mishra and counsel for the petitioner submits that in the meantime, the trial court as well as this court.
In this court, Lok Adalat was Malats held.
In the trial court, twice the matter was referred to mediation, and even the present matter was listed before the National Lok Adalat, second National Lok Adalat, second National Lok Adalat. In all the occasions, the respondent accused has not appeared. It will be cooperated with the proceeding. Mr. Mishra taken me to had drawn my attention to the impugn orders. Impugn order and
Annexure 4,
operating part of the impugn order, and submits that the prime ground for rejection of the application of the petitioner under 143 capital A was that the same was filed on 17/6/2022, that is much prior to the appearance or the reading of the particulars of the accused, which was not at the stage to claim the interim compensation. To claim the interim compensation. In nutshell, the rejection of the application is on the ground that the same was moved prematurely. Mr. Mishra, further draws the attention of this court that the trial has already started.
Well, but my lords, that was a wrong recording of date, my lords.
Submission that the trial court essentially has recorded a wrong date of 17/6/2022. Indeed, the present petitioner moved the application under section 311
21/6/23
143 capital A on
21/6/2023.
21/6/2023. 2023. He further submits that the trial has already proceeded. Two witnesses have examined.
One witness has been examined and they have filed for recall petition 311.
Complainant had already examined witnesses, and the respondent accused has moved application for recalling of those witnesses. And therefore, the trial is prolonged. In view of the same, he fairly submits that if the impugn order is set aside and the liberty is granted to the petitioner, he can renew his plea under section 143A fresh. The submission made by Mr. Mishra deserves merit. Accordingly, the same is allowed, and the impugn order dated so and so, passed by so and so, is set aside with the liberty to the petitioner to move first application under section 143 capital A NIA. If such application is moved, it is expected that the trial court shall consider the same on its own merit without being influenced by the observation already made in the impugn order. With this observation, the petition is dismissed.
Another small prayer, my lords. Because it is of the year 2020 to the case, my lords may fix a time limit so that it can be completed.
It is also he also updates to the notice of he also relied upon the provisions of section 143(2), 6 month time 143(2), 143(2), I think 143(2) of CRPC, that the statute mandate the trial court to dispose of the complaint of the examination within a period of 6 months. Still, the accused respondent has been dragging the case beyond the statutory period. In that view of the nation, even in the event that he moves an application under 143, the same may be directed to dispose of at the early stage. Regarding to the aforementioned provisions of law, to be expected the trial courts can do well to see that the application made by the petitioner under 143 can be disposed of at the early stage. Yes.
Well, that is 143(3).
143(3). Yes, 143(3). Yes.
Extremely grateful.
Yes.
The 50. I'm for the petitioner, my lord. I'm praying for an adjournment. It may be taken up.
Why adjourn?
Lord, conducting counsel, Mr. Behra is.
No, then the interim order will be vacated.
Yes, your lordship. Any day, not today, my lord.
That's the reason interim orders are not passed. In 138 case, you took an interim order. Now you are seeking an adjournment. I'll vacate it. Because 2022, the complaint case. 22. Okay, what have you challenged?
My lord, criminal revision we have challenged. We have moved before this SDGM for discharge petition and 142(2) petition, and same was challenged before the district court under criminal revision, and it was
23/8/2023. Where is that order?
Yeah, order is at annexure. Annexure 8 series, my lord.
8 series or 6 series?
8, my lord. Criminal revision petition, my lord. Order passed in the.
See the prayer. Was the order dated 23/8/2023 and so and so. 23/23. You move application for
Discharge and.
recalling the order of cognizance.
Yes, my lord.
Right, petitioner is the instance of respondent. One complete case under 138 NI Act has been initiated against the petitioner, being the 1 CC case number 109 of 2022. The petitioner is agreed by the order dated order dated 23/8/2023 passed by JMFC Jaipur in the state complaint case. And also the order dated 20/20 passed by the legislations as Karapur in criminal division number 20 of 2023. 23, whereby he absolutely challenge the order of cognizance. This court issued notice by the order dated 1/7/2024. Issued notice to the respondent. And service is complete.
Yes, sir. They have entered into appearance.
Even after service of notice, none has appeared. There is an interim order passed on by the coordinating bench of this court on 1/7/2024. Even counsel for the petitioner is seeking adjournment. In view of the statutory mandate under section 143(3) of the complaint case filed, complaint case section 138 NIFA filed by the respondents ought to have been decided within a outer limit of 6 months. However, the complaint case filed on
Fifteen 7/2022.
15/7/2022.
Yes, your lordship.
15/7/2022, or has been prolonging in view of the interim order passed by this court to be filed is further going below. In that view, the interim order passed was of the stance in interest of justice. Please the method for final hearing after case. Yes, next.
51. My lords may dispose this at not pressed.
Not pressed, no. Mr. Das, learned counsel for the petitioner, that he would not press the petition, hence petition disposed of, it's not pressed, yes.
Thank you. 52.
52, my lord. In this case, the complainant has already expired, my lord. I have filed a petition for substitution. That is IN number 604 of 2020.
What happened?
The complainant within the code below, he has an expired, my lord.
Expired. He's
here is the opposite party, my lord.
The opposite party Shakti Pradha Majumdar, right? Right, counsel for petitioner submits that the respondent Shakti Pradha Majumdar has expired. Therefore, we would bring an answer for this is respondent on record by moving appropriate application.
That is IN number 604 of 26.
You filed already?
I have already filed a soft copy on the petition.
60, where is that? No, it's not.
That is not come. Asine, Aji filed.
He has already filed an application which is not on record. the issue is directed to local the same and the court. Please the matter after vacation. Yes. 53.
You taken up on that
After vacation.
after exchange.
Yes, 53. Total 74 years. Yes. What are these matters? These revision petitions are pending since 2007, and several attempts have been made by this court to settle the dispute. Even it was listed repeatedly before the National Local on 21/11/2013. No. On the page for 26/2007, and currently the ruling proceeds by moving the prisoner of television or something for them. That was on the page for the prisoner, and the matter will be before the further for the petitioner. In view of the same, since the petitioner is not interested to proceed with the case, discuss. Yes. 54.
Opposite party.
Matter has been settled out of court. Payment has already been made by the petitioner to the opposite party in the meantime.
No.
That is what the order dated 13/5/2017.
Already has been made a false statement and accordingly has been recorded.
Right on this revision petition is arising out of so. It is been pending since 2007. The reason of the proceeding of this court dated 13/5/2017 reveals that the petitioner, the counsel for the petitioner made a statement before the court that matter has already been settled and the payment has already been made by the petitioner to the opposite party. However, Mr. Naik, legal counsel appearing for the opposite party, submits that the statement is falsely made before the court. And several attempt has been made. A statement has been falsely made before the local national local on 13/5/2017. And thereafter, the matter was never listed before the court. The matter has been wrongly since 2007, and the petitioner has gone unrepresented. In view of the same, it appears that the petitioner is not interested to proceed with the matter. Accordingly, dismiss. Yes. 55. Yes.
I'm for the opposite party, my lords, on behalf of Mr. Chang.
Anything happened here?
We need to take instructions.
No, please. Pending online, because also from some non-obvious public participant, since petition is not interested to proceed with the dismissal report. Yes. 56.
May I please, your lordship? Here I am for the petitioner. My lord. The petitioner challenges when his 205 petition has been rejected by the trial court. He came here. 205 petition, my lord, for dispense with his personal appearance.
This is arising out of what?
This case is arising out of 138 NI Act.
138 case filed in 2008.
Yes, my lord.
Your application under 205 is rejected.
Yes, yes.
It is pending.
It is 5/9/2009.
What happened to the trial?
I have not received any instruction, if your lordship.
This is unnecessary.
The notice has been issued on 2009. Other side notice has been appeared, my lord. Other side notice has been issued. It has been requested file of 69/2009.
Petition is agreed by the order dated.
Order dated.
What kind of petition is there?
The order dated 18/5/2009.
18/5/2009.
9.
Whereby the learned GMFC
Burville
has rejected his application under section 205 CRPC. Petitioner, petitioner is accused in the 160 case number so and so, arising out of a 138 NIA, initiated by the opposite party number 2. The present revision petition is pending since 2009. 2008. Therefore, I am not going to take this petition and the same basis. Even the petitioner is not sure about the status of the trial of the case. The complaint case appears to have been filed in 2008, and by now the complaint might have been disposed of as well. Leave that as well. I am not inclined to entertain this petition. Next.
57.
My lord, item 57, I'm on BC, my lord. I'm appearing on behalf of Mr. Janmajay Katkia.
Yes. Yes, madam.
I humbly request your lordship to list this matter after vacation.
No authorization. This is also again a complaint of 2008.
Yes, my lord, we need to obtain instruction in this matter, my lord.
I will dismiss it. You move application for restoration.
No, my lord.
Many attempts were made since 2013, 14 and all. Just imagine 2008, 138 case, and you file a revision in interregnum stage and it's pending, and you want adjournment. How can it be granted like this? I don't know. This revision petition.
Your lordship kindly list this matter tomorrow, ma'am.
No, tomorrow. Either argue today or I'll pass the order. I'll pass the order. Keep it. I'll pass
I
the
request
order.
your lordship kindly adjourn.
No, madam.
Kindly
Sorry, I'm
tomorrow,
sorry.
madam.
These are the matters, these are matters creating a lot of trouble in the registry. 2008 matters, I don't. The present revision petition is arising out of order dated so Cognizance order, just imagine. 2008 Cognizance order you are challenging. 138 matters agreed by the order dated 9/1/2009. Passed by London STGM Bhubaneswar in 1CC case number 4836 of 2008, whereby the cognizance of offence, where is that order? Offence under section 138 and I act that has been taken against the petition. The revision petition is pending since so. Pending since 2010. Several attempts have been made by this court for the settlement of the matter by settlement of by it was even listed before the national local authority. Since the complaint case was filed in the year on 19/11/2008, and it is unnecessarily prolonging for about 200 decades. It is belated state. I am not inclined to entertain this petition in view of the statutory mandate under section 143(3) of the NIA. Hence, the petition is dismissed. Yes, next.
58.
Item 58, 2008 matter. There was no stay order as such. We had tried establishing contact with the.
What are you challenging?
Challenging the order of cognizance.
Same order.
Same for the opposite way.
Same order. Same order. Challenging order dated on 10/12/2008, passed by SDJM
Pampos Raulkela in 1CC case number 608 of 2008, whereby the cognizance of offence under section 138 NI Act has been taken against the petitioner. The complaint case was filed. Complaint case has been initiated by the respondent, has been pending since 1/10/2008. 2008. And several attempts were made by this court to get the matter settled. Even the matters were listed before the National Lok Adalat a couple of times, but none had appeared for the parties. Since the since in the petition, the cognizance order has been challenged, and the same is prolonging since last several decades in view of the statutory mandate on section 143(3) of CRPC. I'm not inclined to further entertain this petition, and so the same is dismissed. Yes.
Miscellaneous applications. The miscellaneous applications will also be disposed.
All the applications. Accordingly, all the miscellaneous applications pending in this case.
59.
Yes. Yes. Forget it, copy it. It is pending since how many years? Now you are searching copy 2010. How many years from 2010 to today? 16. After 16 years, you want copy. Tell me what is the order challenge? Where order is from? Set aside the NBW issued. NBW issued in 2010 is challenge, and it is pending. You need a copy. Just tell me. After 16 years, NBW issued and he challenges the NBW, you need a copy. In a 138 case, petitioner has challenged the order dated 26/3/2010, passed by the Court of and then JMFC. JMFC from Karnataka, JMFC Jajpur Road in 1CC case number 150 of 2009, whereby non-bail warrant has been issued. Non-bail warrant has been issued. The non-identity for the distance will be for this one. The complaint is under 138 NI Act initiated by the respondent. It's pending since 2008, since 2009, and unnecessary in view of the one policy dismiss. Yes.
60.
I think 60 I am for the opposite, but file has been misplaced.
What is he challenging?
Well, the file and then
This reason is arising out of the judgment of conviction sentence effections from in appeal, whereby the appellate court affirmed conviction and sentence passed by the trial court from. It has been pending since 2011. And on 4/10/2010. This court has directed the petitioner to deposit an amount of 50,000 towards the fine amount within a period of 4 weeks, and the balance amount was directed to be the balance compensation amount was paid and subject to such payment. Such a none has appeared for the petitioner, so also appeared for the respondent. in view of the aforementioned and the attempt by this court to settle the dispute. This court has also attempted to settle the dispute through local drug, but since due to non-cooperation of the petitioner, the same is prolonged. Hence, the revision petition is dismissed. Yes, next.
61.
One
Yes.
the another sort of a conviction, conforming conviction under 138 of the NI Act. The both the courts below have convicted the petitioner for SI for 6 months and to pay a fine of 5,000.
What is the check amount?
Check amount is 40,000.
40,000 also you are challenging. Two courts convicted. Why don't you pay and finish it up?
Or if may keep it to a short date, I will take instruction. And
What is the compensation amount?
compensation amount is 50,000.
Only 50,000, see.
That is in the year 2010. Now 16 years have passed. It is a case of 2009. It is a 1cc case of.
I'll simply dismiss it and pay it.
Well,
Simply dismiss it.
Lordship may give me short date so that I will.
I'll give short date subject to condition that you deposit 50,000. Otherwise, I'll dismiss. This is for 50,000 rupees. 10 years, your burden is being taken by the High Court. Deposit 50,000 rupees, then I'll entertain. Otherwise, on merit, I'll pass the order. That sentence will remain 6 months. 6 months. You will be in trouble. Deposit it and finish it up.
Today
morning.
I'm for the opposite party too, Your Lordship.
Madam, you take that 50,000 rupees, put an end to it. Unnecessary.
Yes.
There is no end,
Your Lordship, I'll take instructions from my senior.
2010, 40,000, 50,000 rupees means, what is this? Check is only for 40,000 rupees.
Se nobau raji hoji mu demand draft nahi asibe 8 nahi jibe 8 haga hajur cost kar den.
Your Lordship may keep it to another day. We'll take instructions.
No, another day is a tomorrow. He'll come with the money.
Tomorrow, Your Lordship.
Tomorrow haga sange.
Your client must be spending more money to defend the case, engaging you.
Lordship knows these are all cases.
Engaging you.
These are all cases briefed by the lower court councils.
Whatever, but
I have to.
Or he must be spending more. Instead of that, he would have paid the money and finished it up. 22nd. The council. Petitioner fairly commits that the petitioner.
Court aji koyo gale last working day.
The petitioner has been convicted for offence under section 130 of the NI Act to initiate when responded for having the amount to take up rupees 40,000. The trial court convicted the petitioner and sentenced him to undergo SI for 6 months.
6 months and to pay a fine of 5,000.
Pay a fine of rupees 50,000.
The fine of 5,000, compensation of 50,000.
Fine of 5,000, compensation of 50,000, which has been upheld by the appellate court. Hence the revision. Mr. Mishra, counsel for the petitioner fairly submits that the petitioner shall deposit the compensation and fine amount by which date appearing. Without fail. Subject to the petitioner depositing 60,000 rupees deposit, depositing the compensation amount and fine amount besides an amount of rupees 5,500. On 55,000, 1% interest you give, 1%. So then another 5,500. So 61,000 or something.
55,000. And the matter is urgent to so and so. It is made clear that on the next date of hearing, with the demand draft in favor of the respondent to the tune of so we will see 60 so and so is not submitted before this court. The revision petition shall stand dismissed without further deliberation.
You come with the 61, sir, तब उसके बाद देखेंगे. Yes. Immediately after vacation.
Lordship may say it will be hard on merit.
What merit? No merit. Merit is no further deliberation. Pay the money. Thank you. 60,000 rupees you will be time. Yes.
63.
No, immediately after vacation I am keeping it.
हाँ 22 हाँ रखो 22 लोग
22 22nd. We'll pay it, finish it up. Yes.
खाली गोटे instruction नहीं आसले सर.
Yes. Last.
It is also same, my lord, 138 of NI Act conforming. Here the sentence is SI for 10 months and compensation amount is 2,50,000 and the check amount is 2 lakh.
2,50,000 जो है 2,50,000 कर दो after vacation कर दो. Amount कर दो. After vacation कर दो. Little bigger money.
My lord.
After vacation कर दो बेटा same कर दो. सीधा अगरटा 27 कर दो. It is smooth and confirm after vacation. Yes.
64.
And 2,50,000.
64. 64, there is an affidavit by the opposite party, Your Lordship. Affidavit as well as an application where they have admitted that they have got the 60,000 from us.
Sorry, I didn't follow. No, this is arising out of what?
Arising out of 138 NI Act case, Your Lordship. The trial court had awarded the amount of rupees 60,000 to be paid, Your Lordship.
60,000.
Yes, sir. Then again, 72,000 payment of compensation 70,000, Your Lordship. And wrong over there. 70,000, not 60,000, 70,000. That is para 4, Your Lordship.
Yes, read it.
Para 4, Your Lordship. Your Lordship, in the cost title, it goes like.
Will pay 60,000 rupees as a compensation amount and.
Yes, Your Lordship.
And
That has
on
been
it.
paid, Your Lordship.
Where have you said that paid?
Your Lordship, we.
Already paid. Already paid.
Yes, Your Lordship. We have not stated that. Subsequently, in the course of this filing of this revision application, there is an application for compounding, Your Lordship. That is at flag B. Affidavit for
Who has signed it?
Your Lordship, this is by the
The respondent, Anil Kumar
Respondent.
Dikshit. Anil Kumar Dikshit. What is this
Anil
affidavit?
Kumar Dikshit.
He has filed this affidavit.
Yes, Your Lordship. He is filed.
The deponent further declares that I have no kind of grievance on. Okay. I'll dispose it upon that time.
Yes, Your Lordship.
Right,
This is
right.
what I'm saying.
Petition is accused in so case arising out of so good. The court of the first court is says first court is
Order of conviction passed by the learned
Yes.
section judge.
by the order by judgment of conviction order of sentence dated 26/11 July 2011. The court of special judge, special judicial magistrate,
Bhadrak.
special judicial magistrate Bhadrak in 1 CC case number 233 of 29 recorded a conviction against the petitioner for commission of offence under section 138 NI Act and sentenced to what is the sentence? What is the sentence, madam?
Lordship, the
72,000. Immediate deficit considering the facts and circumstances, I sentence convict to undergo simple imprisonment for a period of 3 months and to pay the compensation of rupees 72,000 to the complainant, that is the respondent hearing, respondent. The petitioner assailed the aforementioned judgment of conviction and order of sentence by filing criminal appeal number 14-01 of 2010 before the court of sessions 2010.
before the Court of Additional Sessions, FTC 2, Vadrak. The appellate court, by this judgment dated 1/10/2012, confirmed the same, confirmed the same, hence the present revision. Mr. Mishra, counsel for the petitioner submits that in the during the pendency of the present petition, the parties have entered into settlement, and in pursuance thereto, and the respondent Anil Kumar Dikit has filed an affidavit before this court on 23/6/2013, and it is in the affidavit it is entirely as stated as under para 3, 4 and 5, para 3, 4 and 5. Regarding it to the aforementioned, the present petition is allowed. The conviction and sentence order passed by the Court of Special Judge also and confirmed by the appellate court stands set aside. Yes.
65.
What's the file of the person? If you want to. The present revision petition is arising out of the order being from the matter. The revision petition is pending since 2013. None has appealed for the petitioner. This even the matter was listed before the National Local Advocate also. Despite service, none has appealed for the petitioner. In view of the same, it appears that the petitioner is not interested to pursue the review and hence dismiss. Yes.
66.
Two revisions tagged together. But was had a long back mail. But due to change of assignment, matter could not be disposed.
Yes.
The matter, shared revision number 796 of 13, my lord. I am for the accused petitioner, my lord. The other case, I am for the respondent. That number is 985.
Yes. What is this case? What is this case?
NI case, my lord.
What is the check amount?
8,50,000.
Yes.
I have challenged on 3 grounds, my lord. One is there is no debt at all. And another is notice has not been served on me. So there is no cause of action. And the third one is that the company is not made a party. Check was issued by the company, signed by the present petitioner.
Is there any chance of settlement?
No chance of no. He has subsequently filed 4 cases and all were dismissed.
Division is pending, my lord. Revision is pending in photo.
Where? On the other cases?
Other cases.
Well, my plea is that.
What about the other revisions are after the 2013 only?
No, recently progressed. Disposed of recently, before the trial court.
My lord,
yes. You prepare a written note of submission, I'll hear it. List it in immediately after vacation for hearing. Both the councils.
It appears it is a contesting case. Contesting case. List. Okay. List it after vacation. Yes. Next.
67.
Debt, my lord.
No. After vacation, because it is a contesting case, it has to be heard.
$67 million. Well, check amount is 50,000.
You are for petitioner.
For the petition amount.
Yes.
And the award amount is 75,000.
Hmm.
Already 25,000 has already been deposited before the lower court. In between, amicably settled between both the parties. And at the time of marriage of the complainant, the petitioner gave 1 lakh rupee to the father of the.
Where is those things?
But that receipt, I'll call it only 30 days time kindly be given.
See,
I'll file
sir,
that.
this is 2014. This is pending.
Well,
How many years? Count it now. Count it.
But they told that the counsel for the opposite party will
For
deposit
50,000
affidavit.
for 50,000 rupees,
Well,
this matter is pending since 2014 in the High Court. Just imagine.
But already settled between both the parties, my lord.
That
But
is the
due to counsel for the opposite party not filed any affidavit in this regard.
Okay, I'll dismiss it and you settle your.
But kindly,
Otherwise, show me. No,
in
happy
between,
doing, sir.
in between, I
This-
filed the.
This can't be
affidavit
tolerated.
to myself.
50,000 rupees. See, this when the complaint case was filed, you just imagine. When the complaint case.
Order was filed on.
Complaint case is 2009.
13.
And 130.
Well, order was
Check amount is 50,000.
50,000.
50,000. From 2009, you people are burdening the system.
No, since last, the opposite party, counsel for the opposite party not appear.
I'm not interested to know all these things. The system is being burdened only because of this.
Kindly give a
50,000 check.
last
2009, the trial court is doing and appellate court, the Supreme Court, the High Court. What is this?
Kindly give a
You have
last
some
I will
sympathy for
file.
the system also.
I will file the affidavit. Otherwise, my
Tomorrow,
lord pass the order.
come tomorrow. Maximum I can give tomorrow.
Tomorrow, my virtual court.
I can understand if it's a heavy amount, I will hear it. And for litigation, you people might have spent more than.
As per
the check
direction of
amount.
this honorable court, I have already deposited 25,000 before the lower court.
Deposit another 50.
Well, 15 days time kindly. After vacation, asu mu affidavit file kar debi. Amicable settlement affidavit file kar debi.
The petition is arising out of this order. The next one, the complaint is from which the present revision petition is arising out of was filed year 2009 for dishonor of a check of rupees 50,000. That is very unfortunate that the matter is still prolonging since last 2 decades. And the 2 decades. Land Council for the petitioner submits that out of 75,000 rupees compensation awarded by the courts below, 25,000 rupees he has already deposited before this court. Before this court. When the matter is taken up, he requests for an adjournment. In the interest of justice, adjournment is given to adjournment is given till 22nd of this month, subject to the condition that the petitioners can deposit the 50,000 rupees, 50,000 rupees without fail. In the event the immediate after petition, in the event the petitioner failed to deposit 50,000 rupees, we can appeal it up for 2 weeks from today.
Well, 30 days.
The revision petition will stand dismissed without reference to the courts. Yes.
68.
With 50,000 rupees.
In this case, I am for the accused in the court below, my lord. The petitioner, my lord. The petitioner in this case, my lord, but the accused in the court below, trial court, my lord. That is the check amount
for?
I am for the petitioner.
Yes.
The check amount is 3,50,000. The compensation is 4 lakhs, my lord. And the learned magistrate awarded a sentence, one array of 1 year and fine of 5,000. In the appeal, that is partly allowed that the sentence and the fine amount are then set aside. They confirm the out of compensation. I pray this in the, I am unable to contact the party.
I'll dismiss, then he will come to you. Dismiss in for non-prosecution. Then he will come running to you, then you move application, I'll restore it. That's the only way you can do it.
Lordship, permit me. I have written the letter in 2015. He has not responded. Still the matter is in list.
He will never come. He will never come. If the matters are pending,
one chance,
20 years it will be pending.
Lordship, give me one chance, I will write, otherwise I will dismiss any. I have also yesterday I have also contacted the advocate who has given the brief mail.
I will not record your this thing. I'll simply say that there is no instruction. You have written letter. I'll dismiss it. And liberty.
Any day, Lordship, fix. This is the last letter.
When have you given that?
2015 letter. I have we have not responded.
2014 the
revision
pending. 2015 you have written the letter.
Passed in 13/1/2015. Subsequently, I have written that letter, my lord. He is not responding.
See, the problem, I'll tell you, the problem is when we are spending so much money.
Let's say, give me one chance so that
Pre-Lokadalat. Thereafter Lokadalat. You people don't have a respect. Even a lawyer doesn't come. It is so humiliating for the courts. When that is the reason these matters are listed before court. I will not give it them. Because you people have not respect for the system. See, why have you not come to the Lokadalat? At least somebody should come to the Lokadalat, say that yes, I have an instructor, I don't have an instructor. If you can tell this thing here in the court, why have you not come to the Lokadalat?
I have missed the list.
And how much money is being spent for this arranging Lokadalat and all, you know? Crores and crores rupees of public. For your 50,000 rupees, 20,000 rupees check, we will spend crores of rupees. This is not permissible.
One chance, let's give.
No chance. I will just dismiss it and
let me give day after tomorrow. I will take instruction of the
day after tomorrow. This revision is pending since 2014, and repeated attempts were made by this court for settlement of the settlement. The same held no result. Even in the Lokadalat, second National Lokadalat, nobody appeared for the parties. When this matter is called up, Mr. So and for the petitioner seeks for an adjournment. I am not inclined to grant adjournment in this matter in view of the long pendency of the in view of the fact that the present case is arising out of a complaint case under 138 NI initiated in the year 2006. Only 20 years.
20 years.
2006. However, in the interest of justice, last opportunity in given, release the matter on day after tomorrow. It's made clear that in no circumstances the matter will be examined. 69
On behalf of Mr. Cognizance.
for petitioner.
Yes, ma'am.
Yes.
I will take instructions whether the
No instruction.
opposite party died or not.
If died, then you are lucky. Nothing will happen. He will not press.
My lord, I will.
See, this is also a complaint case filed in the year 2011. No, 2009. Two courts have convicted you. What is the check amount? 1,41,000. 1,41,000. Just imagine. Same order for the day after tomorrow. Because I have given to him, so accordingly, I'll have to give you. Therefore, keep it day after tomorrow. Yes. 70.
Please, madam.
Yes, madam.
Madam, herein the revision has been filed challenging the inclusion of the managing directors as the accused persons to the.
You are the complainant.
Yes, ma'am. No, my lords. I'm the opposite party, my lords.
I am there virtually. I am
You are opposite party.
We are for the opposite parties in the complaint.
We are the accused, my lords.
You are the accused.
Yes, proposed accused. And in the meanwhile, the managing director is dead, my lords. So basically, it has become infructuous, except for the fact that the company is a
I'll simply dismiss it. Non-APS for them. I'll simply dismiss it. Right. This revision petition. What to do? Just imagine it's pending. Nobody is coming, and local also nobody comes.
No, we are there, my lords. We are appearing always.
But for petitioner, nobody came.
We are the petitioners here.
We are the petitioner.
You are the petitioner.
Yes, madam.
Complainant, no one is coming.
Complainant is not appearing.
We have assailed an order wherein we have been implemented under 319, my lords. But that order
what is the order you are assailing? Let us see, understand. Let us understand.
That
You
is
are
an
telling me
order
which
wherein-
order?
They're at Annexure 5, my lord.
Annexure 5. You are the
Vidyut
Powerware Limited.
Yes,
Yes,
You are
Powerware,
Powerware
the
Limited?
corporation, and Vidyut Mahanti, who is since dead.
Okay.
Now,
Okay.
this Powerware, my lords, is a private limited company.
Who has died you according to you, Biswajit Mohanty?
No, Vidyut is dead. Now, Biswajit is also dead since the last 25 days. So, the company is now virtually without any directors.
So there must be some director, private limited company.
No, there were two directors. One was Vidyut, one was Biswajit. Vidyut died out of illness in 2018.
I'll simply dismiss it then. Whatever consequence, I'll dismiss it. We'll see what happens. If anything happens, then you move application for. If nothing happens, just forget it.
Why?
I'll simply dismiss. इतने दिमाग लगा कुछ फायदा है. Right now, the revision petition is pending since 2014. Several attempts were made by the court for settlement of the dispute, and even in the local the matter was listed, but none had appeared. In view of the mandate under section 143(2)(3) of NI Act, the complaint case initiated by the respondent in the year 2013 ought to have been concluded within the stipulated time frame. However, it is prolonging for various reasons. In view of the same, I am not inclined to entertain this petition at this stage. Hence, the petition is dismissed for non-prosecution. And you move application. If anything happens, you move up. It is in fact infructuous. Nobody is dismissed. Yes. 71. Otherwise, you move application. Will survive, revive if anything happens.
Yes, madam.
I am for the opposite party, complainant in court below. In the meantime, the complainant died. The legal heirs of the complainant, they have filed an application for substitution. That is,
What is the check amount?
Check amount to first matter.
Here for
I was on behalf of BB Rauter to ask for an adjournment.
हाँ, এটা খালি আইএটা আসি যাও, আইএটা আসি নাহি.
When have you filed?
IA since 2024, because the file was in the local adalat. 14/12/2024, that I have requested court to send the file to the regular court. जब ये आइएटा लागी पारी नहीं.
Check amount कितनी?
First item 5 lakhs.
And second item?
Second item 3 lakhs, 3.5 lakhs. And the third item 3 lakhs. 1 lakh केवल compensation stay ही थला conviction को लाख टका लगा deposit करी further proceeding माने stay ता है कि
After 2 court convicted.
एथरे substitution टाइम मधे न हले से पैसा मधे नै पे substitution टा आगे टिक हिचला दरकार.
The respondent submits that the complainant, the sole respondent, Ramdev Agrawal, has expired. Therefore, in all the 3 revision petitions, he has to.
The legal heirs,
he has to move appropriate application.
No, already I have filed my lord.
He has already filed.
File IA number 667 of 2024.
He has already filed application.
Application. Registered to.
However, the same is not placed on record. The registry is directed to locate the same and place it on record for appropriate orders.
Day after tomorrow asile setar order ta hai.
Lease the matter. Day after tomorrow for the formal order by.
Number udam dei douch.
Number of days.
తింటేనే వాళ్ళు కాదు.
తింటే
72.
My lord, on behalf of Mr. J.K. Behra, adjourn
Yes.
72 item. On behalf,
Ready?
on behalf J.K. Behra, Gopal Krishnan Bhatta.
No, what is this matter?
My lord, I do not. LCR not.
See,
My lord, Mr. Behra suffering with cancer. That's why he not unable to come to court.
Okay.
Now,
Let the counsel for the petitioner submits that the counsel for the petitioner, Mr. Behra, is terminally ill and hence he seeks adjournment. Please the matter of case.
73.
73 same.
Hmm?
Same.
Same court, Mr. Behra, terminally ill. 74.
74 adjournment.
Yeah.
For appealing for the complainant opposing party number 2.
74.
Lordship, they have not informed us. Moreover, your lordship, after the revision petition was admitted, they have taken an interim bail. Further, there is a stay on the award given by the trial court. And they,
Who has mentioned it? That's the problem. See, we believe the court, we believe the lawyer, He should have intimated you. Move an application. I'll recall it and take it up. Move an application. You specifically mentioned that it behind your back matter was mentioned and got an adjournment. I'll take it up. Okay.